Good morning, ladies and gentlemen. Very good to see you here today. My name is Christopher Sands, and I am the director of the Canada Institute here at the Woodrow Wilson International Center for Scholars. And I want to extend a warm welcome to the people in the room, the people who are watching us live streamed and who will watch the recording later on. This is the first Wilson Canada-U.S. Legal Issues Symposium, and it would not be possible without our partners, the Canada-U.S. Law Institute. You'll hear about both of those organizations as we begin. We are on the record, and we encourage hearty participation. Without further ado, I want to introduce Mark Green. Mark Green is a former congressman, a former ambassador, U.S. ambassador to Tanzania, a former USAID administrator, that's the U.S. Agency for International Development. He's also the president and the CEO of the Woodrow Wilson International Center for Scholars. But appropriately today, I can also introduce him as a proud law school graduate of the University of Wisconsin. Over to you, Mark.
Thanks, Chris, and welcome everyone, physically and virtually, to the Wilson Center. You know, as many of you know, we're truly a unique institution in foreign policy. We're congressionally chartered, we're scholarship-driven, and we're fiercely nonpartisan and independent. That special status, I think, brings with it certain obligations to not duplicate what others are doing, but instead to prioritize the most important issues and opportunities, and to try to do so in ways where we can add value and make a difference. In 1919, as the world reckoned with the horrors of World War I, Woodrow Wilson emerged as the leading advocate for economic sanctions as a nonviolent alternative to war. Speaking in Indianapolis, he said that a nation that is boycotted is a nation that is in sight of surrender. Apply this economic, peaceful, silent, and deadly remedy, and there will be no need for force. 100 years on from that speech, sanctions have become mainstream, a policy tool used to target not only adversarial governments, but also foreign organizations and institutions and entities. In modern times, the widespread adoption and implementation of Magnitsky legislation has made sanctions even more powerful, enabling nations to target foreign individuals and their assets. But as the use of economic sanctions has become more widespread, questions on the utility and effectiveness have become more pointed. Sanctions have not eliminated war, as we know all too well. In fact, in spite of the global sanctions regimes, communities in Eastern Europe, the Middle East, Caribbean, and beyond are suffering some of the worst conflict that we have seen in decades. Questions have also been raised about the humanitarian impact of sanctions, a topic I know our experts will turn to this morning. We are bearing witness to a sea change in the global order. And amidst this transformation, it's imperative, really important, that those nations which share our democratic values and respect for a rules-based international system closely coordinate foreign policy strategies and tools. Canada and the U.S., long-standing security partners with one of the most robust bilateral trade relationships in the world, can and should be a model for the cooperative implementation of sanctions in pursuit of a better world. Achieving alignment, as we know, is not a simple task. It will involve working through two different systems against the backdrop of increasing global instability. Lawyers, many of whom are in this room, and as Chris noted, I'm a recovering attorney myself, will be called on to lead critical debates on the refinement, implementation, and interpretation of economic sanctions legislation. I'm hoping today's presentations and the discussions which ensue can serve as a first step towards that noble purpose. I would like to specifically thank the Canada-U.S. Law Institute, Western University Faculty of Law, and Case Western University School of Law for joining us today. In short, these discussions truly matter. And with that, back to you, Chris.
Thank you very much, Mark. It's now my honor to be able to introduce the Dean of the Case Western University Law School, the great Michael Scharf.
Thank you, Chris.
Of course.
Just a very brief welcome. Case Western Reserve University School of Law for the past 47 years has partnered with Western Ontario School of Law in hosting the Canada-US Law Institute. And with the help of Chris Sands and so many others, we've been able to do these amazing programs both in Cleveland and in Toronto, at Western Ontario, and lately in Washington, D.C. And we're very excited to be partnering with this one, and thank you all for being here. Thanks, Chris.
Michael, we truly wouldn't have been able to do it without you, so thank you very much. And now we go to our first keynote of the day, and it's a chance for me to introduce my former boss, Governor James Blanchard.
Thank you very much, Chris. By the way, those were three of the briefest speeches I've ever heard. I'm from politics, you know, and I'm used to listening to U.S. senators for 45 minutes at a minimum. So thank you, Chris Sands, for your leadership, Mark Green for your directorship, Dean Scharf. Thank you all. I happen to be a proud member of the Canada-U.S. Law Institute Executive Committee, and I have the privilege for the first time, even though we worked together for 15 years, to introduce our keynote speaker, Richard Newcomb, known affectionately as Rick. And I want to get this right, because he has been a leader in international law for several decades. He led for 15 years the international practice group at the global law firm of DLA Piper, a world-renowned international lawyer, expert in sanctions, of course. And he led in the Treasury Department, there's the Office of Foreign Assets Control. Rick led that for 18 years, and basically he oversaw 39 different economic sanction programs that are intended to further our U.S. foreign policy interests and our security goals. I might add, his work received acclaim and distinguished awards from three presidents: President Reagan, my favorite, President Bill Clinton, who appointed me ambassador to Canada, so of course he's my favorite. Are you out there? I can hear you breathing. Anyway, welcome to Zoomland, by the way. We have people joining this forum from Montreal, Toronto, Calgary, all over Canada, Cleveland, Detroit. So we're pleased with this attendance. But I want to again highlight the fact that Rick has been recognized as a distinguished executive by President Reagan, President Clinton, President George H.W. Bush. He also received the highest award the Treasury Department can ever give, and that is a wonderful thing. And he's a dear friend, and a proud graduate of Case Western Reserve Law School, earlier Kenyon College, alma mater of Paul Newman. Anybody remember him? It's a young audience, I know it's tough, but anyway, I'm pleased to introduce a proud graduate of Case Western University Law School and a member of the Executive Committee of the Canada-U.S. Law Institute. Please welcome Rick Newcomb.
Thank you, Jim, for that very kind introduction. It's most appreciated. It is indeed an honor and privilege to be here this morning. I've been asked to provide a brief background and overview of the progression of primary and secondary sanctions over the past several decades. In doing so, I'll provide the context and historical perspective on how we got to where we are now in the primary and secondary use of economic sanctions as one of the primary weapons in the arsenal of options available to the President of the United States in the conduct of his duties in response to a threat from outside of the United States to the national security, foreign policy, or economy of the United States. The history of the use of economic sanctions by the U.S. in the conduct of foreign affairs is rich and with an abundance of examples in the use of this tool in its history, well over 100, significantly more than 100 examples in number. The U.S. has led this effort over the years and during our lifetime has developed the tools and allocated the resources to build the administrative apparatus and support structure to make this an ever more effective option for the president when world peace is threatened, following these key components. First, a strong and coordinated domestic enforcement, strong compliance by major corporate and financial institutions, an administrative body or bodies capable of carrying out the presidential mandate, principally through the issuance of regulations and guidance to define and strengthen the parameters of each sanctions program, ever more effective use of intelligence and law enforcement assets and resources, a strong legal foundation with effective and flexible laws, support and encouragement of the U.S. Congress with new legislation as needed and sometimes when not needed, wide deference by the courts to the executive branch in carrying out its foreign policy and national security objectives, strong executive branch political involvement, and perhaps most important of all these, a stable and dependable currency that the world relies upon as the currency of choice in the international trade of goods and services. The U.S. has all of these, and that has enabled the U.S. to use its jurisdiction over U.S. persons under primary sanctions domestically and economic strength to impose secondary sanctions extraterritorially. To be clear about the distinctions, primary sanctions is the assertion of U.S. jurisdiction to U.S. persons wherever in the world located and any person in the United States. I'll get to secondary sanctions in a moment, but talking about primary sanctions, the use related to the modern economic sanctions were first tested under the Trading with the Enemy Act, a 1917 statute. The predecessor statute to the authority that at the time were programs on Cuba, North Korea, Vietnam, Cambodia, China, and the Axis powers during World War II. Over the years, the courts established deference to the executive in carrying out U.S. foreign policy and national security with respect to the use of economic sanctions. They've evolved over this time and expanded under the International Emergency Economic Powers Act enacted in 1977 for use during peacetime. The first test of this new statute, IEPA, occurred during the Iran hostage crisis of 1979 when 52 U.S. nationals were taken hostage and the Iranian finance minister threatened to withdraw Iran's deposits from U.S. banks and attack the U.S. dollar and foreign exchange markets. The U.S. responded swiftly with a freeze of Iran's assets, which ultimately proved to be some $12 billion of funds and other property, a princely sum at that time. On January 20th, 1981, upon the inauguration of Ronald Reagan as president and the signing of the Algiers Accords, the hostages were freed and a process was initiated to unfreeze assets and address U.S. and Iranian financial and commercial claims and counterclaims. Over the next several years, following the unanimous U.S. Supreme Court decision Dames and Moore v. Donald T. Reagan, U.S. private and corporate bank claims against Iran were settled, many, especially U.S. bank claims, at or near 100 cents on the dollar. The Algiers Accords between the United States and Iran provided for the establishment of the Iran-U.S. Claims Tribunal to hear government-to-government claims between Iran and the U.S. and is the largest and most successful claim settlement program of its kind. Flush on this success of the first Iran sanctions effort, there followed a series of other IEPA-based programs: Nicaragua, South Africa, Libya, Iran again, Panama, Sudan, Syria, Iraq, Kuwait, Myanmar, narcotics traffickers and terrorist organizations, and numerous other country and global law enforcement program initiatives. But my focus will be on Iran, Russia, and the sanctions requirements imposed by the U.S. Congress. In 1995, the president again imposed economic sanctions on Iran, this time for its support of terrorism and its terrorist activities. The 1995 Iranian sanctions initially were promulgated to prevent a U.S. oil company from completing its then lawful contract with Iran to develop the rich South Pars oil field in Iran. When the U.S. oil company was ousted from Iran by executive order by the U.S. president, other non-U.S. oil companies were poised to fill the vacuum and reap the windfall. In response, Congress in 1996 decided that extraterritorial U.S. sanctions or secondary sanctions would help ensure that no other foreign company could do this, and passed the Iran-Libya Sanctions Act, referred to at the time as ILSA, and then only ISA when sanctions on Libya were removed. The law was perceived by foreign oil companies and their host governments as an overwhelming extraterritorial assertion of U.S. economic power. Significantly, however, ILSA had a presidential waiver provision, and enforcement was waived some 40 or more times, every time a non-U.S. oil company engaged in such work in Iran by succeeding in administration. So not until late in the Obama administration, with several new laws, did the Obama administration come to apply what was called secondary sanctions affecting non-U.S. banks and non-U.S. oil companies' dealings with Iran. Secondary sanctions began as a menu of options available to the president under IEPA or other related authority, including especially and most effectively the use of the OFAC Specially Designated National Program. That is, the naming of specific non-U.S. persons or entities acting for or on behalf of the target country, person or entity, or the threat of so naming non-U.S. persons as SDN. The threat is a key issue. Thank you. The practical effect of this threat is to make OFAC programs extraterritorial by forcing non-U.S. entities to cease transaction with such persons or run the risk of being cut off from all ties with the U.S., including especially from the U.S. financial system. Other lesser steps from the menu could be taken as well, but again, I'll stress the threat of designation and the loss of access to the U.S. financial system, financial markets, by making blacklisted as an SDN is what creates the desired chilling effect. World trade in goods and services is conducted primarily in U.S. dollars. International banks rely heavily on access to U.S. correspondent account relationships. No multilateral financial institution or corporation can run the risk of being cut off from the U.S. and the U.S. economy. They go bankrupt if they are. Thus, we have secondary extraterritorial sanctions. A new phase in sanctions development under IEPA followed on the heels of the terrorist attacks of September 11th, 2001. Then President Bush declared comprehensive economic sanctions along with other UN member states against a new kind of target, Osama bin Laden, al-Qaeda, other terrorist groups acting worldwide in what would soon be described thereafter as the global war on terror, and called upon the Treasury Department and the Office of Foreign Assets Control to administer them. Working with other key elements of the U.S. government, law enforcement, intelligence, the diplomatic and military communities, and very closely with U.S. allies, the financial war on terror sought to disrupt the flow of funds to and business relationships and transactions of any nature whatsoever with terrorist groups, their members, and support structure. When members of the congressionally mandated 9/11 Commission issued a follow-up report in 2005 on U.S. response to the attacks of September 11th in its global war on terror, it graded the 5 government elements: military, law enforcement, intelligence, diplomatic, and finance. Of these 5 elements, the financial war on terror got the highest grade, an A rating. The other 4 received scores ranging from B to a failing grade. The Bush administration got the message and became particularly aggressive in the use of economic sanctions as a tool of national security and foreign policy, especially in the wake of September 11th and the high marks the 9/11 Commission gave the financial war on terror. Efforts were redoubled by the Obama, Trump, and Biden administrations, which has used sanctions as the primary tool in the conduct of U.S. foreign policy, reaching new levels in sanctions against Russia following the invasion of Ukraine. Economic sanctions became a prime weapon for Bush and Obama administrations, especially in the war on terror, and in dissuading Iran from the pursuit of nuclear weapons, stopping Russia from further incursions into Ukraine and other nations by severely restricting new debt or equity to specific sector of the Russian economy, defense, metals, mining, oil and gas, and especially for the annexation of Crimea, and then comprehensive sanctions with the war in Ukraine. And the Trump administration continued this as well in tightening primary and secondary sanctions himself against Russia, then Venezuela, North Korea, and reimposed secondary sanctions against Iran and refused to certify Iran's compliance with the Joint Comprehensive Plan of Action. With regard to the many sanctions initiatives on Iran and Russia, the level and complexity of these programs as they have evolved is both comprehensive and targeted. Comprehensive in the sense that virtually all economic activity between U.S. persons and Iran has stopped or heavily regulated since 1995, but especially now in the case of Russia, targeted also with an interesting twist, and that is extraterritoriality. Secondary sanctions evolved over this period of years and served as the model for Iran and now Russia as the sanctions architecture has evolved. And I'll go back and cite the statutes that were passed by Congress that gave the president this authority to move as he did. Starting in 2010, the U.S. government, both Congress and the executive branch, sharpened the choice for non-U.S. financial institutions. If they continue to conduct certain business with Iran, they risk losing access to the U.S. financial system and much more. Congress enacted new legal authorities to restrict correspondent banking or impose broader sanctions on non-U.S. banks that continued conduct to certain businesses with Iran. To briefly summarize an explanation of how these multiple branches coordinated in their efforts against Iran and how this became the model for U.S. secondary sanctions, I'll start with the Comprehensive Iran Sanctions Accountability and Divestment Act of 2010, known as CASADA. It empowered the U.S. Treasury Secretary to prohibit or impose conditions on opening or maintaining U.S. correspondent or payable through accounts for a non-U.S. financial institution found to knowingly engage in sanctionable activities, including those entities that facilitate Iran's WMD acquisition or development, its support for international terrorism, or significant transaction with their Iran's Islamic Revolutionary Guard Corps or other large commercial enterprises. This was followed the next year by the National Defense Appropriations Act, which essentially replicated this CASADA focus on transactions with designated banks, but added Central Bank of Iran as a new criteria for sanctions as well as crude oil purchases. The following year, the Iran Threat Reduction Act amended the Iran Sanctions Act to add a new criteria for the imposition of secondary sanctions on persons doing business in Iran's energy or weapons sector. Then the following year, the Iran Freedom and Counterproliferation Act substantially expanded the already robust framework of U.S. sanctions against Iran, particularly U.S. extraterritorial sanctions on the energy, shipping, and shipbuilding sectors. This was the authority it needed to be acting upon, but acting pursuant to these newly established secondary sanctions laws. It was U.S. imposed sanctions. It was the U.S. that imposed sanctions that contributed significantly to the JCPOA, the Joint Comprehensive Plan of Action, the U.S. conclusion of the agreement itself, and the subsequent withdrawal that constitutes the next major chapter in the history of U.S. secondary sanctions. In June of 2013, President Obama further tightened the economic embargo against Iran by targeting the activities of non-U.S. financial institutions and commercial businesses. This broke new ground, however, by threatening to freeze the U.S. assets of non-U.S. persons who engage in transactions with certain Iranian government agencies and enterprises. The executive order that did this expanded the threat to U.S. automotive sector, again, the second most important business sector in Iran, providing and transactions that provided material assistance to certain persons blocked under laws and regulations. The JCPOA, with this threat, the JCPOA was concluded between Iran, the United States, United Kingdom, France, China, Russia, and Germany, the P7+1, in July of 2015 and went into effect the following January. This agreement outlined specifics regarding how Iran must limit its nuclear power activity to make sure its programs do not result in the creation of nuclear weapons. The JCPOA lifted all secondary sanctions that had been in place against Iran, but did not lift U.S. primary sanctions. However, in August of 2018, President Donald Trump issued an executive order and with it the withdrawal of U.S. from the JCPOA. It reinstated sanctions against Iran, and pursuant to the various legal authorities that were waived or lifted as part of the U.S. commitment under the JCPOA. Since that time, the U.S. had been working with Iran to effect new nuclear agreement, but recent events, notably the sale of drones to Russia and the mass demonstrations highlighting the treatment of women by the so-called morality police, ended this some months ago. And now with the war going on in Israel and Iran's expected support for that hope is now over. Congress's expanding role has taken on a more active role in U.S. secondary sanctions, even those sanctions that traditionally had been in the purview of the president in his conduct of foreign affairs. Iran serves as, here again, as a good example, but there are other cases that I want to specifically point out where the Congress has used legislative targeting against Hezbollah, Russia, North Korea, and others. He inserted greater control in most cases that the president shall make a determination as to whether very specifically defined conduct has occurred, and upon making such a determination, requiring the president to implement sanctions for which Congress has provided the parameters. And the three examples of this, first with regard to Hezbollah, requires the president to prescribe relevant regulations on the opening of maintaining of correspondent accounts or payable through accounts by U.S. foreign financial institutions the president determined to have engaged in any conduct with Hezbollah. The second, perhaps most important, is what's known as CAATSA of 2017, which is the Countering America's Adversaries Through Sanctions Act, or CAATSA. It requires the president to sanction targeted Iranian, Russian, and North Korean sectors and penalize non-U.S. persons for direct or indirect support of them. Under CAATSA's sanctions dealing with Russia, it requires the president to impose secondary sanctions on foreign persons and financial institutions that engage in certain transactions with U.S.-sanctioned Russian parties or in sanctioned Russian activities, such as corruption, human rights abuses, sanctions evaders, certain crude oil projects, and Russian energy pipelines. It also included parameters to make mandatory previously discretionary secondary sanctions involving two prior Russian-U.S. sanctions laws involving Ukraine. And then Global Magnitsky, perhaps the greatest example of purely unlimited extraterritoriality. It exemplified by the passage that the extraterritoriality of U.S. sanctions will continue to expand. And to briefly summarize, the Global Magnitsky Act, which was signed into law in December of 2016, is an expansion of the Sergei-Magnitsky Rule of Law Accountability Act. The original statute enabled the U.S. government to sanction individuals from the Russian Federation for torture, extrajudicial killings, and other human rights violations. The bill was named Sergei Magnitsky, the lawyer who died in prison from police abuse and neglect after exposing fraud by members of the Russian government. The Global Magnitsky Act expands the scope of potential sanctions from covering just Russian nationals to covering persons worldwide who engage in human rights or corruption. Think about this for a second. Together, officials of the Treasury and State Department are empowered to prohibit entry into the United States and freeze assets of people located anywhere in the world considered responsible for corruption and human rights violations. It's a truly remarkable step. The president now has broad authority to blacklist any person of any nationality, whatever, and wherever located, if there's reason to believe that he is involved in fraud or human rights violation. The broadest expansion to date of presidential extraterritorial power. Never in the history have U.S. sanctions had such presidential active interest and play such a direct role in the application and the use of economic sanctions. For example, in North Korea, Iran, Cuba, Venezuela, terrorist groups, and now Russia because of its invasion of Ukraine. To briefly summarize the sanctions on Russia since Russia's invasion of Ukraine, the U.S. and allies and partners around the world have taken numerous incremental steps to impose costs on Russia for the war, including immobilizing some $300 billion worth of assets in the central bank of the Russian Federation, limiting the central bank's ability to aid the war effort and mitigate sanctions' impact, imposing sanctions on Russia's largest financial institutions and restricting dealings with banks, representing 80% of the Russian banking sector, issuing approximately more than 4,000 new amended sanctions listings, including major players in the Russian defense industrial complex and numerous other Russian defense-related firms, as well as non-Russian entities that have provided material support to Russian defense procurement efforts, determining 8 factors of the Russian Federation economy to be sectors in which persons who operate or have operated can be subject to sanctions, namely the financial services, aerospace, electronics, marine, accounting, trust and corporate formation, management consulting, quantum computing. These sector determinations complement the February 22 sanctions administration by OFAC with respect to persons operating in the technology sector and defense and related material sector of the Russian Federation economy, prohibiting new investment of the export of certain goods and services to persons located in Russia, including dollar-denominated banknotes, accounting, management, and trust formation services. The IEPA basis for the Russia program, including in particular the impact of an executive order issued by President Biden in April of 2021, that's some 9 months before the invasion, has served as the basis for the many succeeding executive orders targeting Russia. The features of these executive orders provide wide discretion to the president to isolate Russia from the global financial economies and identify a broad range of sectors of the Russian economy as the predicate for primary and secondary sanctions. The reach of these new Russian sanctions authorities relate to parties' financial and technological support for those primarily sanctioned by providing a broad incursion into the power and chilling effect of secondary sanctions. The threat, fear, and deployment of extraterritorial and secondary sanctions have increased dramatically in recent years, as evidenced by what I've been talking about this morning and by some of these factors. First, going back to the passing of IEPA in 1977, specifically conferred broad power for the president to declare a national emergency under IEPA because of the threat, or whole or in part, from outside of the United States to the foreign policy, national security, economy, and in effect to confer on himself the authority to define the emergency and in the broadest terms declare what steps he would take. Required a report to Congress and making the declaration in an annual report. But keep in mind, the president sets the foreign policy of the United States. He can decide what threatens it. The same can be said about the national security and economy. The president under IEPA has virtually unfettered authority to conduct foreign affairs as he sees fit by the declaration of the national emergency. But Congress, in looking at the legislative history, never contemplated such a sweeping use of the power to deal with trade issues over to the more traditional use of legal authorities for sanctions. The context in 1977 was in the heels of the Church Committee, which was looking to repeal the Trading with the Enemy Act by the broad misuse by multiple administrations of that statute for a variety of other non-Trading with the Enemy Act purposes. The second point I'd make is the growing use of doctrines such as causing a violation, which provides additional enforcement clout based on IEPA principles that the Department of Justice seeks to expand jurisdiction extraterritorially. Causing a violation would occur by a foreign party who misinforms a U.S. party, like a bank, as to what a transaction or a transfer involves. So if it involves a misdescription or incorrect answer as to why the transaction occurred, there's jurisdiction to prosecute that foreign party, a foreign bank, for example, for causing the U.S. to violate a statute. The powerful thrust and expanding use of secondary sanctions against non-U.S. entities, as illustrated by CATSA, can, as well as the affiliates under OFAC, the so-called 50% rule, and the politicization of sanctions is the fourth point I would make. The standard for designation on the OFAC blacklist is reasonable cause to believe, and the administration decides what's reasonable based on all sources of information available. As we all are well aware, neither intelligence nor law enforcement sensitive information in and of itself is evidence. Yet it is increasingly used as the basis for blacklisting of non-U.S. persons for alleged acts that in effect are being denied review to the targeted person. Typically, there's no discovery because it is not a criminal charge. Moreover, intelligence information is not releasable except in camera before a judge, if it ever gets to that point. Thus, there's little, if any, opportunity to effectively challenge without commonly understood notions of due process. Before I close, I want to leave just several thoughts that I always talk in audiences, especially commercial audience, but I think will be relevant here, especially in the U.S.-Canada context. First, for any sanctions program, know the rules for each program, as each one is different. No two sanctions are ever the same. All OFAC sanctions programs are subject to strict liability and very heavily permitted to impose criminal and civil penalties can be issued for violations. Keep in mind, every sanctions program is promulgated by different people at different times for different specific foreign policy reasons. So necessarily, they're all going to be different. Thus, it's critically important for all U.S. banks and all U.S. corporations or anyone doing business worldwide to have a compliance program that is reviewed, continuously improved, updated based on an ongoing risk assessment. Know all the facts of any transaction that may touch on any sanctions program or sanctioned person. OFAC compliance is a very fact-intensive exercise. No two fact patterns are ever the same. I get together often with people that used to work for me in OFAC compliance unit, and we laugh. They're now at the major banks around the world. The one thing we're able to agree on, they have never seen two fact patterns ever the same. They're always different. Know your customer, its owners, directors, and managers. Know your customers' customers and their customers on down the supply chain, direct to the delivery of goods. If doing business internationally, check the OFAC SDN list and for all transactions and understand the 50% rule. Anything owned 50% or more by a blocked person is itself blocked, whether it's listed or not on the OFAC SDN list. And surprisingly, there are some service providers that are able to do that and within a matter of a minute or less, check out who all the parties are that are involved. Do enhanced due diligence, and if and when necessary to assure yourself and partners, including banks, check all sources and keep a record. Pay attention to red flags. Stop whenever you see one and investigate. Don't let yourself be willfully blind. If you find a violation, report it to OFAC or the U.S. State Department or the Justice Department, depending on the facts. Banks in the U.S. and around the world are de-risking. Even if authorized, banks increasingly will not process a transaction involving or touching a sanctioned country, or do business with anyone that has unlawfully done business with a sanctioned person or country. Understand there's a significant amount of lawful business between U.S. companies with Iran and Russia and other sanctioned countries, and know the difference. If in doubt how to proceed, seek expert counsel. Finally, as I said earlier, I want to make one additional point, and there's a reason why the U.S. President has sanctions in his toolbox as an effective enforcement tool for the conduct of foreign affairs, the U.S. dollar. It has served since at least World War II as the world's reserve currency. International trade in goods predominantly is dominated in U.S. dollars, 70% or more. Oil trades in dollars. It's dependable, especially as goods trade on the high seas, commodities trade. Dollar is the one currency they can depend on. Countries and banks around the world rely on it. Most international banks are totally dependent on U.S. correspondent banking relationships. And if they lose that because of a sanctions violation, which has happened, they're out of business, period. This is a tremendously powerful tool for the U.S. when world peace is threatened. And should the reliability, dependability, or reputation become uncertain through overuse of sanctions or a default to meet debt obligations, the U.S. could lose this considerable leverage it has over international banking system. Other currencies are available, but should a default occur, then it's doubtful they could pick up the very important role the U.S. has had all these years. I'll leave it at that, and I look forward to the program today, and we'll answer any questions you may have. And it's exciting to have this session, and I thank you all.
Thank you very much, Rick. That was a master class in economic sanctions. One of the best things about being here at the Wilson Center is not only the chance to hear such good, insightful food for thought, but also to have great colleagues. And although the Canada Institute gets all the credit here, I have to say my colleague, Mark Kennedy, who is the director of the WABA Institute for Strategic Competition, very much fits in this frame. This is something that he works on all the time. And so with no further ado, let me introduce you to the Honorable Mark Kennedy.
Thank you, Chris, and thanks for everybody being here today. I lead the WABA Institute for Strategic Competition, and in fact, we do focus on things like sanctions and the economic statecraft that we are implementing more aggressively, as we just heard from our illustrious speaker. This is getting to be a more complicated world out there. I thought I wanted to be a lawyer when I grew up. I ended up being in business, and as a business person first, then a congressman, then a university president, I listened to everything we just heard and say, wow, it's tough to do business out there. That's why you need good lawyers to help you navigate through this. And that's why we need these types of situations in conferences to talk through some of the complexity. At the beginning of your remarks of our previous speaker, he just said, this only happens if you have an effective implementation of a regime within a country. Well, I would suggest it also really only happens if you have that effective regime with other partner countries. And that partner countries begin with Canada. And that's why this conference is important. And to take us to the next step of understanding how these sanctions work, how U.S. and Canada work together, we are pleased to have with us Stephen Alsace, the Global Head of Economic Sanctions at the Royal Bank of Canada, who has the ideal background to help us understand this even further. Stephen Alsace is RBC's, Royal Bank of Canada's, Global Head of Economic Sanctions. In this role, Stephen is accountable for leading and implementing RBC's Global Economic Sanctions Program and is a member of the Financial Crimes Operating Committee. He has been dealing with sanctions issues since 2010. Prior to joining RBC in 2022, Stephen was the director of the Global Investigations and Compliance practice of Guidehouse, a McLean, Virginia-based consulting firm where he was the Canadian practice lead for financial crime, fraud, and investigative services. He also worked 19 years for CIBC, first in their legal department and later as the global head of sanctions and terrorist financing. Stephen frequently speaks at conferences on sanction matters in Canada, the U.S., UK, and Europe, and has provided sanctions and terrorist financing instruction to the Royal Canadian Mounted Police, the FBI, and MI5. Stephen has also appeared twice as a sanctions expert before Canadian parliamentary and Senate committees. He holds law degrees from the University of Windsor and the University of Detroit Mercy, as well as a master's degree in European Studies from the University of Strasbourg in France. Please welcome Stephen Alsace as our next speaker.
Thanks, Mark, for those kind words. And let me just say it's an honor to actually be invited to the Wilson Institute to be able to deliver a keynote address. In a way, Rick, it's almost like being able to meet one of my heroes. And I have to say congratulations for all of the work that you've done in building, the OFAC sanctions program and the framework. I mean, of course, with the government, but clearly it is like the preeminent guide to sanctions, and the influence it has worldwide is incredible. And I'll speak to that a little bit further in my presentation. In terms of sanctions compliance, I'm going to approach it from more of a business aspect in our interactions with legal counsel, and maybe talk a little bit about the emerging complexity of sanctions, talk a little bit about friction, especially when we're looking at the evolution of financial services and where we're going today, and also talk about the need to continue with collaboration, because it is so important. What I've seen in my 17 years or so of dealing with sanctions, when I first started as a lawyer, working in the legal department for a bank, and I need to preface this, these are my comments from me personally, and they don't necessarily reflect my employer. I have to say that so I don't get in trouble, because I often will say things that'll get me in trouble. When I started, I really wasn't an expert in sanctions. I started working in the financial transactions group supporting commercial banking. On the side, they said, oh, hey, well, the AML lawyer just kind of quit, so can you do AML? And by the way, you're also getting sanctions. I went, okay, great, fine. I knew what AML actually was. Not so much sanctions. I said, yeah, it's kind of trade related. That's fine, okay. So as it evolved, I would have to go home and I'd see my mother, and she's like, oh, what are you doing? And I moved to a different department. What do you do now? And I said, I do sanctions. She's like, oh, that's nice, dear. Thank you very much, right? And she would go on, knowing that she didn't really know what sanctions really was. Come to 2022, and following the Russian invasion of Ukraine, it was fascinating because she came over to me excited. She's like, you work in sanctions. I actually know what that is now. And it's funny because she's, and she's this very tiny Jewish Japanese woman, which is interesting growing up. Have you ever had ramen in matzo ball soup? It's an interesting combination. But so... but she said, very excitedly, and she was truthful about this. She's like, I was talking to my friends, and you may want to consider, and she actually drew up a list of Russian individuals that she thought were sketchy. And she's like, here, you can, and she thought she was helping me. How will you take this? It doesn't work like that, Mom, but okay, sure. Thank you. I'll take that. I'll go talk to some of my colleagues at Global Affairs. Maybe it'll come up in conversation sometime, right? No, but it just shows to you how I think sanctions has come to the forefront of everyday parlance. People you run into on the street now know what sanctions are and how important they are. And I actually credit that to the work that OFAC has done, right? And from an enforcement perspective, but it also shows how important it is for Western nations to actually continue collaboration in this regard. Collaboration is key for us to be able to bring sanctions to the next level. And what I mean by that is really being able to operationalize sanctions beyond just the tight group of major financial institutions, because that's actually where it's going next. So to bring it back to, 2014 was a very significant event, because when we saw the first Russian invasion of Crimea, and it's interesting how there are so many parallels to what's happened in 2022, a new type of sanction emerged, sectoral sanctions. Now, going from the comprehensive and the targeted sanctions, we could deal with that, right? From an operationalization perspective, you do list reviews, you purchase that, you've got screening filters that are in place, you have controls that you can implement. But this was new, the sectoral, because it was targeting certain industries. But when you look at being able to implement those types of sanctions for payments, let's take SWIFT wire payments, right? This is liquidity. This is the way money moves around the world. Was a challenge, and I remember when they first dropped, being in my office, reading them. First thing I did, get on the phone with our external counsel. Right? What is this? Have you seen this? Reading through it, and I remember for a 24-hour period, it was frantic. I reached out to our counsel in New York saying, are you aware of this? Yeah, read through it. Okay. So we had a series of transactions, payments, right, involving Russia. Can we actually make these? Don't know. We need to look at this. I said, well, we need to answer this fast because we actually have to be able to clear transactions daily, right, to be able to maintain liquidity. Let's call our counsel in Washington. Not sure. Okay. Let's call our counsel in London. Let's call our counsel in Belgium. We actually are on the phone with lawyers from around the world. I reached out to all my colleagues in Canada. I reached out to our correspondent colleagues for correspondent banks in the U.S. Transactions actually stopped for a 24-hour period. I'm not sure if people are aware of that. Right after these sanctions actually dropped globally, there was a huge impact to liquidity. Within the next day, they continued, but it just goes to show you the power of sanctions and the power of ambiguity related to sanctions because everyone was so concerned about violating them, primary and secondary. From a Canadian perspective, not only obviously secondary sanctions are important, but so are primary. Why? Because most of the big banks operate in the United States. As Rick stated, global currency is US dollar. So that means that pretty much any type of international settlement, most settlements are in US dollars, including foreign currency transactions, usually will end up settling in US dollars. That means you have a US nexus now to a US correspondent, which makes it very complicated for Canadian companies when they're operating, even within the law. When you have someone that's on a U.S. sanctions list, but they're not on a U.K. or Canadian sanctions list, and there are quite a few of them. So it's a very fine line that we actually have to tread, saying, can we actually clear these transactions? If they're in U.S. dollars, no. If they're in pound sterling or euro, possibly. But then we get into a very complicated assessment of whether or not we have a U.S. nexus to the transaction based on personnel that are involved in it, where it's actually cleared. So what ends up happening? Banks de-risk from those markets because it's too complicated. And when you have complications, you also see an increase in costs of compliance. Compliance is essential, and you need controls in place to be able to manage this risk. But it's getting more and more complicated, especially when you start looking at issues like sectoral sanctions, when they're actually impacting certain sectors. So it is a challenge. 2014 also saw a lot of enforcement actions, and this is really where you see the power of, I'm going to call it the power of OFAC. It was really, at that time, I'll say the power of Ben Losky from the New York Department of Financial Services. When you start seeing fines in the range of $9 billion levied against foreign banks mostly, right? BNPP was the first. You got Standard Chartered, Deutsche Bank, Danske Bank, Credit Suisse, one after the other. From a Canadian perspective, we all just went, whoa, holy cow. In one respect, it was great. Not for stress great, but great in the sense that it gave leverage to compliance departments, compliance professionals like myself to be able to say, this is the impact if you do not follow sanctions. Now, obviously, in those situations, or most of those situations, you had other factors involved, like stripping, et cetera, right? And in other instances, you had repeat offenses. But still, you are talking about a strict liability regime when you're talking about U.S. sanctions. Canada, it is not strict liability. Canadian sanctions, under the Special Economic Measures Act, you need to actually formulate intent. And perhaps that's why there's such a stark difference between the two countries. Canada, to date, I'm aware of one successful prosecution by Canadian authorities against a company for contravening Canadian sanctions, Lee Specialties. This was back in 2014. It was a Red Deer, Alberta company. They shipped O-rings valued about $15 to Iran in contravention of Special Economic Measures Act regulations for Iran, resulting in a $90,000 fine. That's the only one that I'm aware of in Canada. I mean, somebody else might be able to come up with another one. Very few. That's not to say that Canadian firms aren't subject to sanctions enforcement. There have been at least 3 of the big 5 Canadian banks have entered into deferred prosecution agreements because of enforcement actions by OFAC for their operations in the United States. Is there any wood here? Knock on wood. The 2 banks that haven't been caught are the 2 banks that I was head of sanctions program. I'm just saying that maybe it's a coincidence. No, I don't like to think so, but anyway. In some respects, it could just be luck, because I have to say, banks are trying to do their best, but it's a challenge just because of the complexity, again, involved in implementing effective sanctions programs. All right, Rick mentioned about the importance of doing certain things like KYC. The challenge, let's look at customer due diligence KYC. From a Canadian perspective, again, the United States, actually, it's much easier because you actually have a 50% plus 1 rule. Canada doesn't. In Canada, up until just last year, we didn't actually know what it was. We didn't really have any guidance around, well, is a majority of beneficial ownership caught? In Bill C-47 that passed and was in effect in June 22nd of just this past year, clarified now the beneficial ownership rule for Canada under SEMA. But the challenge is it's not 50 plus 1. It includes indirect or direct control. Okay, so it's a control test. Interesting. It indicates if the individual has the ability to influence or appoint directors of the board of directors. Okay. How do you make that determination? What documentation do you now need to be able to prove that that shareholder may or may not be able to appoint a member of the board of directors? Or actually, it's influence or change the board of directors, or as a member of a committee of the board. So it's a whole level of complexity now has been added to this assessment. And for financial institutions that have millions of clients where you've already done your due diligence on them, how do you actually refresh your files now? So, well, perhaps we could take a risk-based approach. Again, I'm pointing to the guidance of OFAC, right? So outside of, I think we're up to maybe 1,300 FAQs, somewhere around there. It's over 1,200. Canada, we do not have any guidance around this. We don't have any published guidance. We've been asking for, I've been at this, since 2010. Since then, we've been asking Global Affairs to publish guidance around interpretation of sanctions. They're working on it, which is great. And this is the importance of being able to collaborate with the department. But to date, we don't have anything published. So that's just one area where it makes it challenging, not just for financial institution and other firms to be able to interpret the requirements for sanctions. It makes it difficult for our legal counsel to be able to provide advice on this. When many times we've asked legal counsel, okay, well, how should we proceed? The answer tends to be, well, we're not exactly sure. The only way you can be sure if this transaction or this party is okay to proceed with, you may have to ask for a specific permit from Global Affairs Canada, which is what we do. The challenge about that is that let's look at some of the transactions that we're facing. We have them in the hundreds. Again, so the major difference between Canada and the United States, you have general licenses that can be applicable, right? So where you actually are carving out certain exemptions, and you also have a period of time before they're actually implemented in force. Canada doesn't. When new sanctions drop, they're effective that day. In some cases, they're actually backdated. So when they're published, they're effective 3 days before they're actually published, which is confusing and challenging.
And I understand, actually speaking to the Department of Finance around that, the rationale was they knew that most of the banks use service providers that generate the lists that we ingest to actually do our screening, and that's why they did that, to be able to account for it. But it's still not clear to the banks whether then the expectation is that you're going to actually re-review your transactions. So you have to do a look back every time the new regulations drop. A lot of us are doing that anyway, or we pick it up like as soon as we see it on a website to make sure that it gets implemented, same day, to be able to avoid that risk. But again, these are ongoing challenges, right? So with respect to like the permit applications, could take upwards. We have some that have been in queue for over a year. So operationally, it can be a challenge, right? Day to day. There's some good things though. I mean, in terms of, the Canadian approach, Canada, for a long time under the Russia-CIMA sanctions, we actually had more listings than the United States did. Canada is taking a very aggressive position when it comes to sanctions deployment. But the reality is we look to the U.S. For alliance from an enforcement perspective. Canada today doesn't actually have a sanctions regulator. We have the RCMP that will press charges. They seek guidance from Global Affairs Canada. Global Affairs Canada is the one that actually publishes the sanctions, but there is actually no oversight branch for sanctions because it doesn't actually fall within FINTRAC. FINTRAC's our financial intelligence unit, and they actually regulate all the banks. FINTRAC's authority is limited to AML. It doesn't actually extend to sanctions. So there's actually a gap that's been in place since 2017, since the Office of Superintendent of Financial Institutions actually backed out of this area in Canada. Because you had two regulators that were regulating the banks. You had OSFI and FINTRAC. They were kind of going to head in exams, and it was causing a lot of friction. So the Department of Finance said, oh, yeah, we'll just get rid of OSFI. Well, they didn't get rid of them. They're still a prudential regulator. But they don't do examinations for financial crime anymore. So there's been a hole since 2017. Now, I've been speaking to Global Affairs and the Department of Finance. We know that there are plans in place to be able to remedy that. But the reality is, since that date, we really haven't had anyone to actually oversee sanctions compliance. So what do you do in Canada? Well, we're all very polite. We're nice. We do the right thing, right? Usually, yes, we do. No, we don't have to worry about it because most of the large financial institutions have to comply with sanctions, have robust sanctions, because we're constantly being assessed by U.S. regulators for our programs. So it's covered. I remember attending conferences in Europe, and I was having a conversation with my counterpart in Holland, and one of the regulators from Holland was there too. And I asked about this, and I said, does Holland have a sanctions regulator? No, we rely on OFAC, is what he told me, which I found actually very curious. But I mean, that's the reality of the world that we're in today. I'm going to talk a little bit about where we're actually going and why it's important to continue this dialogue around sanctions and the implementation of sanctions and being able to address the complexity of sanctions. We're seeing a lot of pressures, whether it's in Europe, Canada, North America, open banking. You're seeing a lot more payment rails cross-border being person to person. You're seeing fintechs being introduced into this world where they're actually allowing payments to travel from one country to the next. So it's actually outside of SWIFT. So when you look at SWIFT, the Society of Interbank Payments, that's all the members of SWIFT have robust sanctions screening in place. Fintechs, not so sure. It depends on their jurisdiction and who actually has regulatory oversight over them. In Canada, it's a bit of a debate. In Canada, there is some oversight from FINTRAC, but the problem is they only have to be registered with FINTRAC, meaning they have to report AML requirements. Nothing in Canadian legislation expressly stipulates that they have to have sanction screening in place. So if they're operating mostly in Canada, but they don't have a U.S. presence per se, but they may be settling transactions in U.S. dollars, that potentially becomes a problem. The other pressures that you have around the real-time payments, particularly small value payments, not only is the fact that They may or may not have sanction screening enabled for their clients or for the transaction itself, increasing pressure to actually enable faster payments processing. So that's the notion of friction. Sanctions cause friction to payments. Why? Because you have to screen. Well, when you screen, what happens? You get false positive alerts. And your false positives of the alerts have to be actioned somehow. You take it out of the queue and you have to work it separately. Well, you have to have a mechanism to be able to move it off of the rail. You have to have a mechanism to be able to issue an RFI. You have to have a mechanism to obtain additional information, especially when you look at sectoral sanctions, or you're looking at the sanctions that might be connected to someone more than just an SDN, but it could be to the underlying purpose of the transaction. So although we are seeing movement to an ISO 222 standard, and really all that really means is that richer payment information will flow with the payment, you won't necessarily have the purpose of the transaction, and the data quality may be questionable. What does that result in? It means friction. It means potentially companies won't do it. It means you have to have a mechanism to be able to address that, especially for transactions that are expected to clear in not a minute, 300 microseconds or less is the standard. That's far below a minute. These are almost real-time payments. So being able to implement not just sanctions, but other compliance controls against that kind of traffic, how do you do that? That's the challenge that we face today. And that's the reality, not just in Canada, the United States, it's global. Collaboration and communication. I think we need to come up with better ways of complying with requirements from multiple jurisdictions. Alignment is crucial. So where you get hiccups or when you actually have differences between lists, right? Because you have one country that says, oh, this person is sanctioned, and then the other country says, no, they're not. So we're seeing better alignment, particularly between the G7. You see that recently with Myanmar. You actually have alignment now with the G7 around who's actually going to be listed. That's great, right? More of that is crucial, that collaboration. Collaboration also is important with regulators in multiple jurisdictions, not just the United States and Canada. And I'm talking about not just the sanctions regulators or in the banking or whoever controls the rails for financial payments. It's with any privacy advocates and privacy departments. Why? When you look at being able to reduce friction, part of the causes of friction is the fact that multiple hops or points along the way in processing that transaction are being rescreened by each entity over and over again. What does that result in? Enormous inefficiencies. Okay, you look at it, and it also delays it. So we as a bank, if we're initiating a transaction, okay, we screen it, great, move it over. Oh, look, it's in another currency. That intermediary bank, they have to screen it, move on to the next one. Beneficiary bank, they get it, they have to screen it along the way. Why do we do that? Well, because we don't really trust each other, because we think, oh, we have different standards. We've started collaborating with a consortium service provider that's comprised with 40 other banks globally to look at doing things differently. We're saying, hey, how about we use an ODFI model, meaning that's a reliance model, where the originating depository financial institution screens both legs of the transaction, or if there are multiple legs, they screen all of them once. But all the participants agree to that standard. Setting a baseline standard that way can actually make sanction screening more efficient, more effective. And it also helps with enforcement and making sure that, and compliance with sanctions requirements. But getting agreement to allow the sharing of the information necessary along the pathway is critical. That's why privacy departments for respective nations need to be engaged in this discussion. Right? And the more banks that can actually hop on board, again, we're not talking about anti-competitive behavior here. This is really efficiencies for compliance. We're all in the same boat. We've been involved in those discussions, and we've had a lot of success. So I think that's going to be the key to moving forward. And it'll also provide an avenue, or at least a solution, for fintechs, money services business, non-banks, to actually follow the same standards that banks have been following for the last 2 decades, right? So to me, that's the future, what we're seeing. It's something that Canada is trying to lead. We're being very forceful on this. We'd like to see a bit more traction from participants in the United States. But we have to move in that direction because the costs of compliance are becoming excessive. The difficulties and the challenges with compliance are also becoming more and more apparent. Part of the solution is also leveraging the use of generative AI to help improve sanctions and alert resolution. So critically important, as the next trend we're also seeing when we talk about complexity, is the bleeding of the definition of what constitutes sanctions into the world of export controls. Before, we used to see a clear division between those two areas, right? You'd have OFAC do their thing, BIS do their thing. They're now seeing collaboration, which is great from a departmental level, very challenging from an implementation perspective. Why? Because we don't have as rich information when you're processing a payment as you might have on an export. You don't have the same level of documentation. Now, you might argue that you have that for documentary letters of credit if you're doing trade finance transaction, but it's a very unique niche. When you start looking at the payments end of it, which are actually separate, they're bifurcated. You've got usually the trade documents and the settlement happens somewhere else. You don't necessarily have the same level of detail. And we're finding in both the US and Canadian legislation, the regulations, and particularly in Canada, when you look at the CIMA schedules, they started including harmonized codes, HS codes, in the description of some of the items. And included in that is Chapter 85. If you ever look at HS Chapter 85, it's massive, right? It's basically electronics, right? So it's so broad that, okay, we understand the intent here, but the problem is the application. We need some guidance around it because that means we have to actually stop any type of payment that actually references electronics involving Russia. Now we lead back to the complexity and possibly de-risking. You know what? It's actually perhaps easier to just de-risk and not process any transactions with certain countries because of the level of complexity now that you have to implement. So that's a challenge. It is a challenge, especially when you look at the unintended consequences, because you still have people, ordinary citizens who do want to be able to complete transactions, let's say in Russia, pension payments. It could even be, we've got hockey teams that we've seen where it's just a question about their payroll that's being interrupted. Humanitarian aid is the next piece of it, right? When you start looking at countries like Iran and Syria, right? And unintended consequences that it may start interrupting humanitarian aid to some of these countries just simply because it's too difficult to be able to implement adequate controls because it's not acceptable anymore to be able to do everything manually. Thank you. I think I'm about time, so I appreciate listening to me, and I think we're going to get insight in. We're going to have great discussions later on this morning. Thank you.
Well, ladies and gentlemen, thank you very much. And for those of you watching on screen, as well as those in the room, we're going to take a 15-minute break.
All right, hello everybody. Welcome back to our symposium. For those of you who are out there on the internet, we have an intensely and impressive small crowd here in the building, and we have several hundred people, including many of our Canadian colleagues, participating through the internet. I'm Michael Scharf. I was introduced earlier, but again, I'm the Dean at Case Western Reserve University School of Law. In that capacity, I'm also the co-president of the Canada-U.S. Law Institute, which is a partner in today's program. And I have many hats. I'm also the president of the American branch of the International Law Association. But the most relevant hat is a former hat. 35 years ago, Rick Newcomb and I worked together when I was in the office of the legal advisor at the State Department, and I was the lawyer in charge of sanctions, in particular United Nations imposed sanctions. So we go way back, and it's great to be back on this issue, which was one of the first in my professional career. It's a pleasure to serve as the moderator and introduce our first panel on U.S. sanctions. The panel will discuss how and why the United States uses economic sanctions, focusing especially on recent developments, new tools, and contemporary challenges. So let me introduce our panelists briefly. We have Rachel Lingus, Chief Sanctions Economist at the U.S. Department of the Treasury, and we have Michael Cass Antony, Senior Advisor and Team Lead, Sanctions Policy and Implementation at the U.S. Department of State. So our panel is 1 hour. We're going to start out with 10-minute presentations, but the panel is really designed to be quite a discussion. And so while you're hearing these initial presentations, please start writing down questions so you're ready to rock and roll. I have some that I will throw in there if there's a pause. But without further ado, let's begin with, which of you want to go first? Rachel?
I'm happy to go.
Rachel.
Okay. Okay, I think I don't need to adjust the microphone. So thank you, Michael, and thank you to the Woodrow Wilson Center for hosting this discussion. So I like the framing of sanctions as an evolving practice and as an evolving tool used by policymakers. And I think that's really the perspective that I bring to sanctions policy. So my division within OFAC is the Sanctions Economic Analysis Division, and it's a newly created division within OFAC that just started operations around 6 months ago this year. So what is this exactly, and how are we applying economic analysis to sanctions tools, and what is really the rationale behind something like this? Well, this division was set up as an outcome of the 2021 sanctions review that was commissioned by Secretary Yellen. And some of the findings of that review, which is in a public report now, included the concept that sanctions targets are becoming ever more complex. There's increasing reliance on this tool. Designations have grown really exponentially since the introduction of some of these new authorities within Treasury, kind of looking over the past 10 years or so. And there was a finding that really sanctions can be more effective while reducing unintended consequences by reviewing ex ante the economic and financial impacts of proposed sanctions actions, as well as after effect, kind of looking at our existing sanctions programs and doing more economic and financial analysis to identify lessons learned, potential areas for mitigation. So that's really my mandate. And having this function really centralized within OFAC, I find is incredibly valuable because there's kind of other parts of Treasury undertaking economic analysis, right, that maybe focus more on the international financial institutions, or we do have our econ policy colleagues focusing more on domestic policy, but really there was a need to have this kind of dedicated resource within OFAC supporting sanctions design up front, and as well as after action. So we're aiming to provide globally consistent approach to economic and financial policy analysis to better inform sanctions as design. So this is really a global mandate. And I would add that, we're still in startup mode, and there's not, while one area that I found particularly useful is kind of coordination of information and economic analysis with allies and partners. So as sanctions capabilities start to add capacity, which we've seen particularly after Russia's invasion of Ukraine, there is sort of a strong desire for collaboration across sanctions bodies and a need to share information. So I feel like this is sort of a place where we can really step in with these analytical tools and help coordinate and share analytical lessons learned, identify upfront with partners potential areas for mitigation in advance of taking joint actions. Now, with respect to Canada, I can say that Canada is a strong ally, part of the G7 as well as Five Eyes, and we share many of the same values and ideals, particularly as it relates to human rights, Russia, Ukraine, and counterterrorism. And really, in a way, my function is meant to help magnify the impact of undertaking joint actions by using analysis to inform it. And we found that over time, too, taking joint actions with partners such as Canada can bolster the impact of U.S. sanctions. So I can give a few examples. In 2021, the EU, the UK, and Canada sanctioned Chinese government officials in connection with serious human rights abuses in Xinjiang. Complementary actions using global human rights sanctions regime enable like-minded partners to form a unified front to identify, promote accountability for, and disrupt access to the international financial system by those who abuse human rights. And more recently, we've undertaken joint action with Canada and other partners, such as this year, sanctioning the former president of the Haitian Chamber of Deputies for his extensive involvement in corruption. And as Undersecretary Nelson has stated, these actions help to hold accountable those who have undermined the integrity of Haiti's government in destabilizing their country. And I would add that Canada has played a very important role in coordinating actions with the U.S., other G7 partners in Australia around the price cap. And this is an area I think that my team is starting to add some important analysis to understanding the efficacy of this policy over time and helping to tighten it over time as well to crack down on evasion, which is the focus of our policymakers. And then I would add, too, that in terms of analysis of unintended consequences, last month, many of you know that the United States and Treasury, in particular, issued some general licenses for Venezuela in various sectors, authorizing transactions involved in the oil and gas sector, the gold sector, as well as removing the ban on secondary trading. And the U.S. will continue to hold bad actors accountable and support the Venezuelan people and Venezuelan democracy. But in around some of the license, you saw language from Treasury's policymakers on particularly providing a limited general license to Minervan for to kind of authorize transactions in the gold sector. There was an assessment that this would help reduce black market activity. So this is an area that my team has undertaken some analysis to see, since sanctions were imposed, has there been an increase in trade discrepancies, exports to imports of gold in the region that might suggest that some of this trade is moving to the black market? And we found quite a bit of evidence that there was. So this is an example of using the tools to understand what's going on when we do implement kind of large sectoral sanctions of this kind to be able to inform kind of future policy design. So with that, I'll turn to Michael to talk a little bit more about some of the importance that I alluded to in terms of increasing efficacy of sanctions by working with international partners, because it's really so key to what we do.
Thanks, Rachel. And thanks, Dean Scharf, for moderating the panel. And thank you to the Wilson Center and the Canada and U.S. Law Institute for hosting this event and inviting me to participate. As Dean Scharf mentioned, I'm a senior advisor and team lead in the State Department's Office of Economic Sanctions Policy and Implementation, which is responsible for developing and implementing sanctions policy as well as coordinating with partners and allies on sanctions issues. Specifically, I lead our teams focused on Europe and Africa to include Russia. I lead our sanctions targeting, policy and coordination efforts, and kind of broader thinking around our economic pressure campaign against Russia. I'll particularly speak in the context of that because I think it's a great example of our coordination with allies and partners, specifically Canada, over the last 20 months since Russia's invasion. So the State Department plays an important role in our efforts to both hold Russia accountable for its invasion as well as to combat attempts by Russia to circumvent and evade our sanctions and other measures. The State Department provides foreign policy guidance to the interagency and in support of our economic pressure campaign. we also coordinate closely with allies to ensure we are eliminating loopholes and maintaining pressure on Russia. We work heavily with our interagency partners, particularly at the Treasury and Commerce departments, to do a lot of this, to facilitate this international outreach and coordination. As you may be aware, the State Department also plays an important role in sanctions designations under our Russia sanctions program. Under Executive Order 14024, the primary Russia sanctions authority, the State Department holds dual designation authority with the Department of Treasury, allowing each department, in consultation with the other, to implement sanctions against individuals and entities. Under that authority, the State Department has rolled out over 700 designations since the beginning of February 2022. The combination of responsibilities has put the State Department really at the forefront of this response. In discussing the U.S. government's overall response to Russia's invasion, though, I think it's important to take stock of where we are nearly 20 months into Russia's renewed invasion of Ukraine in February 2022. As of August of 2023, the UN Commissioner for Human Rights estimated that nearly 10,000 civilians are dead and over 16,000 maimed or injured. The numbers are truly likely higher. In response to Russia's invasion, the United States and dozens of international partners representing half of the global economy imposed sweeping and unprecedented restrictive economic measures against Russia. A central objective of our sanctions and export controls is to limit Russia's ability to support its war effort, both by reducing its revenues and denying Russia access to critical inputs and materials it needs to persecute its war. Since Russia's invasion, the U.S. government has designated over 2,000 Russia-related targets, including senior Russian Federation officials, over 80% of Russia's banking sector by assets, and more than 600 defense sector entities. Treasury has also identified 16 sectors of the Russian Federation economy in which the United States may impose sanctions. With our allies, as Rachel alluded to, we've also imposed a price cap on Russia's maritime exports of oil and refined products through a services prohibition in order to reduce Russia's most important source of revenue, its energy revenues. In addition to specific sanctions, export control measures have been central to the efforts of the United States, but also of the broader coalition in continuing to hold and impose costs on Russia. Since Russia's further invasion, we have denied all U.S. exports, re-exports, and transfers of items subject to the Export Administration regulations to Russian and Belarusian end users, and we have targeted the end users themselves. Using the Foreign Direct Product Rule, we have also increased the reach of our controls. The Foreign Direct Product Rule requires licenses for the transfer to Russia of foreign origin items produced using advanced U.S. technologies, tools, and softwares. This has resulted in a drop to near zero of exports from the U.S., EU, and G7 to Russia. As Rachel mentioned, our sanctions against Russia have been unprecedented in their scope. The response has also been novel. The U.S. government has been creative in identifying new tools and methods or repurposing existing ones. Our response has been so strong in no small part because of the extraordinary allied and partner coordination that led up to and since the invasion. Together with allies and partners around the world, we have isolated Russia from the international financial system, immobilized major portions of its sovereign assets, put downward pressure on its most important sources of revenue from energy, and dramatically reduced access to critical materials and technology necessary for Russia to persecute its war. Our strongest partnerships are with members of the G7, including, of course, Canada. Since before the invasion, we have engaged in near weekly coordination with partners to ensure our strategy and policy efforts remain aligned. Our legal authorities are different, but by sharing our objectives and strategies, as well as targets, we've synchronized our regimes to minimize gaps and increase pressure. And we continue to learn from each other as the war has gone on. There is also great cooperation on the export control side, where the United States has worked with allies and partners to build a coalition of nearly 40 countries implementing substantially similar export control measures against Russia and Belarus. This greatly expands the reach and impact of our measures beyond what either the United States or any of our partners could have achieved alone. Unsurprisingly, as the war has drawn on, the Kremlin continues to seek ways to circumvent or evade our sanctions and export control measures. This circumvention is not easy. It requires Russia to find new suppliers, transportation routes, and payment channels. Our coordination with allies and partners is one of the most powerful tools we have to limit this activity and increase the effectiveness of our measures. This effort to prevent sanctions evasion is multifaceted, and I'll speak about two main components, I think, where allied coordination is particularly impactful. So first, updating and expanding our prohibitions and designations to close any loopholes and strengthen the effectiveness of our measures. As we learn about payment channels, critical inputs to military supplies, and other relevant elements to Russia's efforts in Ukraine, we respond and endeavor to shut down this trade. This includes sharing information amongst close partners to shutter evasion channels, tighten our collective rules, and expand designations to cut off supplies to Russia. As part of this effort, the U.S. worked directly with the UK and EU to jointly publish a list of 38 common high-priority items that Russia seeks to use to persecute its war. This list was recently expanded to 45 items and is published on the Department of Commerce website. On the U.S. side, the Commerce and State Departments are continuously reviewing items recovered from Russia's weapons systems to identify materials necessary that Russia needs in order to continue its war. A second and major component of our efforts to stop sanctions and export control evasion is to engage transit countries around the world on our measures and the importance of implementation and enforcement. In particular, we work with our close partners to engage governments and private sectors in key third country jurisdictions to stop the flow of critical high-priority goods to the Russian battlefield. This effort is ongoing, but we have seen encouraging results through these multilateral campaigns. They've both increased adherence to international sanctions and export control measures, and it's been evident to us as we reviewed trade data that this joint outreach with partners is having an effect. Maybe just to close my opening remarks, since the beginning of the invasion, the administration has prioritized working extremely closely with partners and allies. It's really, I would say it's really been the key defining factor of our response to Russia's invasion of Ukraine, and I think the results bear that out. Doing so has allowed us to properly frame this context, not just an attack on Ukrainian territory, but as one that threatens long-established global norms and rules that have been central to global stability for so many decades. This coordination has been instrumental also in building our collective economic response to international aggression. The structure that we've built will be essential as we approach nearly 2 years of conflict in Ukraine and as we look forward to others in the future. And I think I'll stop there.
All right. Well, that's a great way to kick this off, both Rachel and Mike. And while you're thinking about your questions, I'm going to hit them with a couple just to start us off. This one is for both of you. And in Steve's keynote, you ended it, I'm looking at Steve, with some concern about interrupting humanitarian aid. And I know that there's a Security Council resolution from 2 years ago that says sanctions should be interpreted as in a way not to disrupt the flow of humanitarian aid. And there's an executive order that passed about the same time that says the same thing. So I wondered if the two of you could comment on how that plays with respect to Steve's concern.
Sure, I'm happy to start. So I think from the example of a Russia context, and thanks for the UN resolution and the corresponding executive order that came out, I think to Steve's earlier point, the U.S. and international partners have made it a priority to ensure that humanitarian aid travels unencumbered, despite the numerous sanctions and export control measures that are put into effect. I think you saw that with the issuance of OFAC's General License 6C that specifically enables the transport of food and agricultural and medicine products. I think you've seen that we've continuously tried to clarify our position as well, working with foreign partners. So recently, not so recent anymore. Over the summer, the UK and the US published a joint FAQ focused on what our humanitarian exemptions in the food and agricultural sector are, so that private sector participants could kind of understand where there was allowable transactions and where things could happen. So I think we've put a number of effects into place. I would say that it's an ongoing effort. We're continuously trying to ensure that this trade remains unencumbered, and continuously looking and working with OFAC to kind of clarify guidance and ensure that private sector enterprises have what they need in order to kind of continue to facilitate this activity.
Did you want to add anything?
I think on the flip side that there's a lot that can be better understood by understanding the extent to which trade is still flowing from Russia did actually have a record production of grain this year, and a lot of that trade is actually flowing through overland routes through Ukraine. Whereas, the Black Sea is much cheaper to ship a lot of these goods. And that, has been, that trade has been more encumbered by direct actions of Russia. I think that our exemptions and licenses for this kind of trade to flow are very important and have been in existence since, the start of the war. And we've been very clear in providing guidance for industry and private sector on its existence. But I think that there's still a big information gap there, and a lot of it might be perception as well. And I think that, unfortunately, we are dealing with a certain degree of kind of Ministry of Communication from Russia, sort of portraying kind of declines in trade as sanctions, when we can keep pointing to the exemptions that we have in place and make sure that industry understands it. I think on the flip side that we need to get out more better information on kind of the extent to which this trade is still flowing, and the extent to which, other actors have stepped in to provide grain and fertilizers if some trade remains encumbered through these cheaper routes through the Black Sea. So I see that as an area that kind of my function and that economists can step in and kind of provide more information, more of the data underpinning some of the narrative. But I think that in this particular case, that there's a little bit of an information gap that can be bolstered by kind of better data on what trade is actually flowing, kind of the extent to which, it's a big leap to kind of claim that when we have these broad exemptions that sanctions are kind of undermining this trade. But I think getting the data out there is very important.
My next question's for you, Rachel. You mentioned the sanctions on Venezuela, and I know for the last decade, the United States has mostly been going at it alone. It hasn't been a broad international effort. My understanding is the purpose of the sanctions are twofold. One, to facilitate regime change, and two, to facilitate change in the regime's policies. And neither of those things have really happened. And for a variety of reasons, including some that you mentioned, the sanctions haven't been particularly effective at achieving those and other purposes. And so you just mentioned, I hadn't known this, that we're starting to ease up on those sanctions. Can you tell us more about the lessons learned from Venezuela? Because I know we all have been talking about Iran and Russia, but Venezuela is sort of off the radar, and it might be the laboratory with the most interesting insights. So I thought you might share some of those.
Sure, Michael, I'm very glad that you asked me, about Venezuela. And I do think that there's in a lot of these cases where there's been very comprehensive sanctions passed and time has gone on, we have kind of an opportunity there. And I think that a lot of researchers in the academic community are understanding this as well, that there's actually data to be able to understand the efficacy of some of these measures. With respect to the Venezuela program, you mentioned the goals of those sanctions. I think that all along our policymakers have been clear is that these measures are intended to encourage the authorities to undertake free and fair elections, right? And I want to emphasize that that's very much remains the case, right, with the current easing of those sanctions under these 6-month general licenses that has been issued. I think at the same time, there is a willingness under the current administration to take a look at this again and try to see if we can move the needle. So I think that it's an important case that, as you mentioned, a lot of these sanctions were implemented by the United States. And I think in terms of kind of understanding the extent to which there were unintended consequences, I think I mentioned specifically the gold sector and kind of illicit trading of gold, and whether sanctions perhaps contributed to that. I think that that's something that we're still examining. I mean, there's certainly a question of policies as well, and some of those policies predicated sanctions. But I think that in these cases that it's very important to be able to look back and understand what occurred and kind of assess the efficacy over time, and it can contribute to better and more effective sanctions design in the future.
And now let me switch back to Michael. With respect to the sanctions on Russia, you have mentioned there are many, many countries, over half the GDP of the world, are with us on the sanctions, but it's not all of the world. And unlike the sanctions originally imposed on Iran for their nuclear capabilities, there's no Security Council resolution imposing these because Russia would veto that. So we have, for example, India, which has been acting as sort of a war profiteer, importing more and more oil from Russia and then re-importing it on the world market and making a lot of money and undermining our effort to try to keep Russia from exporting its oil. What's the solution to that?
Sure. Well, if I may, just to speak about the price cap for a second. The price cap has two specific twin goals. So the first of that is to limit energy revenues specifically to Russia, right? Is what I talked about. But the other and key part of this is to maintain stability in the commodities of oil and refined products on the global market. And so in support of that second objective, the United States actually does not have immense issues with India continuing to import Russian oil at below the oil price cap. That continues to be something we want to promote in order to make sure oil continues to travel freely and the market stability remains there. What we obviously do want to do, not just with the price cap, but with all of our efforts, is work with countries like India and others around the world who, while they may not have explicitly joined our sanctions coalition or imposed measures themselves, work with them to make sure they understand their responsibilities under our authorities and kind of the reach of some of our tools to be able to get at evasion as it happens in their jurisdiction. So that's a continued effort. But I think it's important to remember that, the price cap was very intentionally designed to do this. It was very intentionally designed to make sure that this was happening. We recognize that countries are getting cheaper oil, but every barrel of cheaper oil they are getting that Russia has to sell at a discount is less money that Russia has to persecute its war. So in actuality, it is what we want. I know that it seems counterintuitive, and you read articles in the New York Times that talk about all the profiting that India is doing off of this. But it is within our interest to do so. And as kind of Rachel said, we continue to work within the price cap coalition with, of course, Canada and the G7 and Australia on figuring out how to kind of tighten our rules and regulations to ensure better compliance. You saw that with the designations we rolled out about a month ago in that vein. So we're kind of continuing that effort, and it's an ongoing process to make sure that the price cap is being enforced as possible. But yeah, it's an ongoing effort and something we're continuing to do.
And I think that's a nuance that most people didn't fully understand. So I'm glad you were able to clarify that. Let me ask one last question and then open it up to all of you, because I see a lot of eager faces in the audience. And this is with respect to Rick Newcomb mentioning how the use of secondary sanctions and the executive authority has really expanded. And that's one of the ways that we're able to try to impose sanctions when there's not a Security Council resolution and get as much of the world behind them. But let me ask both of you this. I mentioned before the Security Council veto. We can't get a Security Council resolution against Russia because they have a veto. But in this context of Ukraine, the General Assembly, at the U.S. urging, has been using the Uniting for Peace mechanism, which was created in 1950 as a way to circumvent the veto, first used when Russia was vetoing the UN forces in Korea during the Korean War. And it hadn't been used for 30 years, and now in the last year it's been used 5 times against Russia. So the first time was to condemn the act of aggression. The second time was to say the plebiscites were unlawful in East Donbass, in the eastern part of Ukraine that Russia tried to have. The third was to expel Russia from the Human Rights Council. The fourth created a registry so that people who lost land or lives will eventually be able to get at these frozen assets. That's a whole other area of sanctions that's interesting. But why not go for a 6th resolution to impose sanctions? And even if these are not enforceable because it's a General Assembly rather than Security Council, it would at least give political credibility to the countries that haven't joined the sanctions. It would help get them off the fence, and it might help them with respect to legal arguments about violating trade agreements and so forth. So the question is, have anybody been talking about a sanctions resolution using this mechanism?
I would defer to,
the State
to
Department?
the State
Yeah.
Department on
I would-
dynamics within the UN.
Of
yeah.
course, I would say specifically that my office doesn't deal with UN sanctions, most principally, so I can't speak really specifically about those efforts. I know that there are conversations ongoing about ways in which we can utilize the UN to create legitimacy for the response to Russia's aggression and to kind of call out and condemn the atrocious acts that Russia has committed in Ukraine. I can't speak specifically on the Uniting for Peace resolution or anything with that. I would say that, in terms of building credibility, we understand, I think the U.S. government has seen kind of reactions of various countries since the war began. But I think, again, it's important to remember what is really at stake and where it started and what's going on in Ukraine. I try to turn it back to that every time we have a discussion about some of these other things. And Rachel talked a little bit about food prices as well, which is something that often comes up as our sanctions being responsible for increase in that. I think, as Rachel brought up, and Russia has clearly exacerbated markets with its invasion, both specifically by inflating the cost of its goods and making it harder for those goods to travel, but also doing things like pulling out of the Black Sea Grain Initiative, which allowed grain to travel really freely and easily through the Black Sea.
Or targeting infrastructure.
Or
right?
targeting-
It's even used for food shipments.
Yeah.
And I think that the more we need to emphasize and kind of discuss this, and kind of bring those data points out into understanding of kind of what's going on, because I think that we are kind of running up against literally a propaganda machine from Russia that's trying to tie sanctions directly to food prices. When, in my assessment, the evidence linking those two things is much weaker.
Well, we have 25 minutes left. Let's have questions from the audience, starting with Jim Blanchard.
This is great, thank you. To what extent do the Russian people feel the effect of sanctions? My question is, to what extent do the Russian people feel the sanctions, the effect of them?
Sure, I can take that one. So I think that one thing that I would make very clear is kind of our goals, as Michael previously alluded to, particularly around Russia's invasion of Ukraine and kind of what we're utilizing these sanctions for. It's number one, kind of reduce the regime's access to revenues used to finance the war. And, the biggest revenue generator for Russia, I think it's about 60% or so, is through the oil and gas sector. So that's where kind of the price cap comes in. But also to reduce their access to material used to be able to implement this war. So that's specifically material utilized for its military-industrial complex. So when you think about those two things, sort of fiscal revenues, used to finance the war, and kind of material support for the army, those aren't designed necessarily or particularly to make the everyday Russians' lives more difficult, right? So I just want to be very clear up front. I think that being said, as over time, as Russia's kind of lost some of these revenues due in part to the efficacy of the price cap policy, but the sort of expenditure needs for the war have actually tripled over time, that there is a bit of a crunch there because they are now having to rely more on non-monetary sources of finance. And they have been running kind of effectively a fiscal stimulus over time. So we see a little bit of those impacts in terms of rising inflation in Russia. I mean, that case would not have existed had they not been at war and had some restrictions in their access to oil and gas revenue. So that's kind of one area in which it's become kind of harder for kind of from a domestic economy perspective. But I think also there's the question of a lot of multinational corporations and Western service providers have pulled out of Russia earlier on. And so those kinds of things do impact people day to day. So I guess my response to that is it's kind of bearing out more and more over time, and particularly from a macro perspective, the more costly the war becomes. And it is costly in part due to sanctions, right? Due to limiting the Russian government's ability to get these material support for the war, and kind of less oil and gas revenue. And by making it more costly, there's a need to make trade-offs, find alternative sources of revenue, impose lots of surprise taxes, on different companies operating in Russia. But I think that there has been a contribution to inflation too domestically.
Can I ask you, Rachel, the flip side of that, and that is, what has been the cost to the U.S. economy by our sanctions on Russia?
So the cost to the U.S. economy by our sanctions on Russia, I think, has been fairly limited, I would say. I mean, I think particularly in terms of how the price cap policy was designed, there was an understanding that we didn't want to design sanctions that would create havoc in oil and gas prices, right? So Michael mentioned that this policy was designed to kind of keep Russian oil and gas, not prevent it from being sold on international markets, but to essentially kind of force them to sell it at a discount to others. So the U.S. is not and has never been a large consumer of Russian oil and gas. So I think, fortunately for us, changes in that market didn't impact our consumption, but I think we've been able to mitigate any disruptions in oil and gas prices that were strictly caused by any measures that we were taking, right? There's sort of a question of if there hadn't been a war in the first place, if Russia hadn't launched this invasion of Ukraine, I mean, certainly the global economy would be in a much better place. But we can't pin that on sanctions, because I think that we've been very thoughtful in how we've designed our sanctions such that it wouldn't create havoc in oil and gas markets, and it's not going to make it more difficult for kind of the average American citizen.
If I might just give one brief remark to the initial question, because I think Rachel's points were really important, right? So that it's important to remember that our campaign against Russia has been something that we expect to see play out over time, and that since the beginning of the imposition of our measures, the Russian government has taken specific steps to both prop up its currency and prop up its economy. And as Rachel noted, with extra taxes on oil and gas revenues and a bunch of other mechanisms the Russian government is putting in place, it's starting to feel the effects. And it's going to start having to make tough decisions regarding whether or not to fund its war and do some of these other things, as well as whether or not to provide domestic support at home in a number of the social services and basic needs of an economy that it's been doing for a long time. These choices were intentional. We want the government of Russia to have to think twice about continuing to send artillery into Ukraine and to continue bombing Ukraine. And so that's been part of the effort the entire time. But I just wanted to put a finer point on that.
More questions from the audience. Oh, there's lots of hands up. How about with you? There's a microphone coming so that our listeners out on the internet can hear you.
Thank you. My name is Roberta Lajou. I'm a fellow at the Woodrow Wilson Center, and I am from Mexico. And I would like to bring up the question of long-term sanctions through the example of Cuba. Economic sanctions to Cuba have not worked. The Cuban government is alive and well, and it has justified its existence and its legitimacy because of sanctions. There's a sort of the worst of both worlds. I was Mexican ambassador to Cuba, and at that time, U.S. trade with Cuba was larger than Cuban trade with Mexico or Canada, both countries having diplomatic relations, on the basis of humanitarian aid, which expands and expands and expands and helps the Cuban economy go on. So my question goes to the evaluation of long-term sanctions, economic sanctions, in the case of Cuba, that has not been mentioned in this seminar and is something to reckon with, especially the increasing support every year Cuba gets in the UN resolutions calling for the end of sanctions, with more and more countries participating. And if it will not have the same effect on Russia, throwing Russia into the arms of China. There is hearsay, I have no proof or hard information, that many economic transactions of Russia are being done now through China. What information do you have about that?
Either of you.
Okay, I would say, you know, with respect to sanctions on Cuba, you know, it's kind of much broader than just OFAC authorities. So there's also legislation and such. You know, I can't comment on the specifics of all that implementation, but I will say that there is a strong willingness under this administration to examine cases, particularly cases in which there have been comprehensive sanctions, and identify if sanctions can be removed over time. So, you know, I can say kind of more broadly, not just focus specifically on the Cuba case. And then you mentioned kind of looking at that and understanding its bearing on Russia. I mean, I would say that kind of the use of this kind of comprehensive trade embargoes and those types of sanctions is really less prevalent in Treasury's application of sanctions now, which has shifted over time to more of list-based authorities. And I think that that's in part to be more focused and targeted in our sanctions and kind of tying it more explicitly to kind of the proposed goals of those sanctions. So that is meant to say that the use of kind of comprehensive trade embargoes is less common, and it's kind of not a tool that I think that you know, that we take lightly in imposing. And I do want to note too that, like, as Michael and I have mentioned, that's very much not the approach taken to the sanctions on Russia, which I think have more focused goals that we mentioned at the outset. So one, kind of reducing revenues for the authorities, and two, limiting access to materials used to prosecute that war in Ukraine.
Rachel, can I ask a follow-up question? You mentioned that the sanctions on Cuba are imposed by Congress, and there's a lot of politics involved, presidential politics. But can the executive branch do waivers on the congressionally imposed sanctions on Cuba? Is there that ability?
There is that ability. There is that ability, but you know, I can't speak to kind of like internal discussions with respect to Cuba.
I would just say I can't speak to Cuba either, both because my knowledge in the areas that I cover is separate. But I would also say that it is a thorny battle to get into continuing to grant waivers on mandatory sanctions that Congress has imposed. So that's something that continuously the executive branch, specifically State and Treasury, are weighing and balancing as we look to our actions. But I think what Rachel said is important regarding our response on Russia and why it's different than some of the embargoes that we've put on other countries, because it is so specifically targeted, because Russia is and was such an internationally connected country and continues to remain so. I think that, you know, as I think our speakers earlier talked about, the U.S. dollar continues to remain critical to a number of international transactions, and especially large ones that happen in the energy space or other, frankly, large transactions. They often end up resolving in U.S. dollars. And so for that reason, while we know some of this trade that Russia is doing has shifted towards other countries, including China, we continue to remain confident that our sanctions will continue to be effective. And remember that, you know, the end goal of our sanctions is really to enable Russia to stop its aggression in Ukraine, to come back to some sort of negotiated settlement, whatever that is, whenever that is. But it's not to continue to impose costs unnecessarily should circumstances change and should the behavior change.
Steve, you had your hand up.
Oh, I was just going to make a comment and actually ask a follow-up question. Thank you. With respect to Cuba, because I didn't actually have time. It was in my presentation, but I ran out of time. Canada loves Cuba, and we actually have a different approach to Cuba than the United States has for years. Canada has a lot of trade and tourism and investment in Cuba, but that actually presents quite a challenge for Canada, particularly with respect to our friends in the United States. Canada has something called the Foreign Extraterritorial Measures Act, which is intended to actually counteract Helms-Burton. And back in 1997, there was a big row, I don't know if anybody remembers that, over the Walmart pajamas. These are $9 pajamas that, they were on the shelf, purchased by Walmart in Canada. Somebody complained saying, how can you have Cuban pajamas for sale that were sourced by Walmart, U.S. company? So then all the stores within Canada for Walmart pulled all the pajamas off the shelves. It was a complaint was raised to the Attorney General's office in Canada saying, no, under FEMA, you have to put those pajamas back on the shelf. So this whole issue, diplomatic row erupted, right, between the government of Canada and the United States. Eventually it was resolved, I think, because Canada agreed to not to have the pajamas sold on the shelves. It turned out that apparently they were highly flammable as well. So they actually represented a safety issue for children. But then that was like the justification for pulling them off the shelves, right? And Walmart changed the source, right? So they were no longer produced in Cuba. But I do want to ask a follow-up question with respect to China and Chinese sanctions. I'm curious as to the thoughts there. To what extent, in the event of an invasion of Taiwan, is the United States looking at expanded sanctions?
I don't think I can comment specifically on what the United States is looking at in response to any kind of potential issues in that part of the world. I would say that, as you saw from our response to Russia's invasion of Ukraine, we continue to work closely with allies and partners around the world to figure out what our response would be in the event of a specific situation, wherever that might occur, wherever hostilities occur. As I think I said in my remarks, our kind of efforts in Russia and Ukraine have kind of been paramount in building a lot of these coordination mechanisms, which remain in effect. And so I remain confident that if something were to happen in another part of the world, we are in a better place now to respond to it from an economic pressure perspective than we were prior to February 2022.
And most experts that I'm reading about say that China is looking very closely at how we respond to the Russian invasion of Ukraine, both militarily and economically, in determining its costs and benefits for future action against Taiwan. So I think that's something you can't say, but it's clear that that's the subtext. All right, way back in the back of the room there.
Thank you. Great conversation. My name is Chase Winner I'm a reporter with Energy Intelligence. Two questions, if I may. One for Rachel, specifically on Iran, since the Iran's now exporting anywhere 1.2, 1.4 million barrels a day, largely to China, and that trade is outside of the U.S. financial system. With teapots, refiners in China. So I guess the question is there really anything the U.S. can do about that trade? I know there's pressure coming from Congress. There's the SHIP Act passed the House on Friday, for example, and there's been speculation that it was an intentional policy by the Biden administration to sort of ease tensions with Iran before, but obviously given events between Hamas and Israel, that calculation, I'm assuming, is going to change. So if you could please talk to that. And specifically, can you really do anything if it's outside the U.S. financial system? And to Michael, you mentioned that the U.S. is coordinating with G7 partners on not only the price cap, but other issues. Last week, I believe, you guys announced a lot of sanctions, so I forget the timing sometimes. But last week, I believe you announced sanctions on the Arctic LNG 2 again project, which if everybody doesn't know what that is basically a major project that Russia's working on to sort of expand their natural gas exports. And this one targeted Novatek's basically Novatech, a contractor. And so that raises questions whether or not, did you coordinate with G7 and, for example, France, because Total is a partner in that project. I believe it's 10-20%, and presumably now need to exit the project. Could you speak to that? And did you coordinate? Do you coordinate on big announcements like that? Okay, thank you.
Rachel, do you want to go first?
Sure. So, with respect to Iran, based on my purview, I can't comment on the specifics in terms of measures being considered. But sort of a broader comment on kind of trade undertaken outside of the U.S. financial system, and if there are kind of what do we do about that? I kind of touching on Michael's comments earlier. I think that when specifically with the Russia case and kind of undertaking more trade with Russia and China more trade with China to help kind of get some of the goods that might have been cut off from EU shipments, for example. I think one kind of point that I would make is that those are often costlier transactions, right? So, just because like so I'd be much less concerned about kind of any material impact on use of the US dollar over time, because I think these are on such a small scale, but also in certain cases they're much costlier for the countries that need to kind of shift and find alternative suppliers.
On the Arctic LNG 2 question, so just to start, I think that one of our broader efforts in the Russia space is to curtail Russia's ability to produce revenues from future energy revenues specifically. So it's been a very intentional effort within the United States, specifically state and treasury, of taking actions to curtail future energy revenue projects, because that revenue could potentially be used, obviously, to redirect profits towards Russia's war machine in Ukraine. I would say that with any large action that we take, we are heavily coordinated with partners. So you should expect that with these efforts that we took, we worked closely both with the French, but as well as the Japanese, both of whom have oil companies that maintain large stakes in the project. I also would say that, while we designated the project company this most recent time, we had designated additional contractors and subsidiaries kind of throughout to make it in our intentions kind of clear that this is a project that we do not want to go forward because it will create additional revenue for the Russian regime to be able to use for its nefarious purposes. I would also say just more generally, because I think you asked a question specifically about the stakes that Total and others have in the project. And so that's something we work really closely with OFAC on, and we routinely get requests for licenses to be able to divest or do other things from projects, and especially with complicated matters like this, we expect those to come. And so we'll continue working on that. But energy is not only an important source of revenue for the Russian government, but it's something that it continues to wield and kind of hold over others closer in its jurisdiction, right, like Ukraine. And so in the same ways that it continues to do that, and many partners have had to decouple themselves from Russian energy channels over the last 20 months, we'll continue to kind of cripple its ability to future produce that revenue and to bring more of those projects online as we can.
There were some questions over there. Sir, yeah.
Hi, Leo Newman, former senior advisor in the Canadian government, and spent the last year in DC studying at Johns Hopkins SAIS. I'd be really curious to hear from both of you your perspective on sanctions in terms of the lifting of them. And I know over the last while we have talked about sanctions, and we have implemented them at rapid pace and probably more extensively than ever before. And I can see a world where we would continue doing that in a lot of other parts of the world. But I'd be really curious to hear your perspective in terms of the lifting, because I think we often see them as kind of a one-way street where we sort of impose different sanctions and then there is no, it's all stick and there's no carrot at the end of it. And I guess I'd be curious to hear from both of you in terms of how you see the lifting of them and where that plays into the role of economic sanctions to have incentives at the end of the day as well.
Sure. So again, very important question. And under this administration, there is more of a concerted focus on looking at cases in which we've imposed sanctions. And, there might be evidence over time that, were they effective as intended? And what was our intended goal for using this tool? And kind of was it the best fit for this purpose? There's sort of a broad gamut of considering cases of sanctions removal. So, I referenced these list-based sanctions, more targeted, and, there is petition process around being able to lift sanctions on individuals. And, OFAC does engage quite a bit with private industry and partners on those cases. And I think that certainly there are cases, in which those types of sanctions have been removed, right? But then there's kind of much broader cases where you're looking at sectoral sanctions, and I'd say that it's very much kind of case specific. So there's not really any kind of blanket policy or effort to broadly just remove sanctions, but I think that in terms of kind of dealing with actors where we're still kind of seeking behavior change, or we're still seeking free and fair elections, in some of these countries, that there has to be kind of conversation and diplomacy surrounding any kind of efforts for sanctions relief. So I think that's very much kind of the case, this recent case in Venezuela that I mentioned earlier. But I think that for any other case, that it would have to be part of kind of a concerted diplomatic effort, ideally involving allies and partners. But I think that there very much is kind of a willingness to be able to use those carrots, as you say, in addition to the sticks, particularly in cases where sanctions have been imposed for a long period of time, and the situation has changed quite a bit since they were initially imposed. And so it might merit kind of examining it further.
Yeah, I think you've seen under this administration that there's a willingness to kind of roll back certain measures. I think, as Rachel kind of started her comments saying, there was the Treasury sanctions review that came out a year and a half ago, which said that sanctions should be clear, but also should be reversible when that becomes necessary as well. So I do think that's a position of this administration, and it more happens specifically. The Venezuela example made headlines and you hear about it a lot, but you don't hear about the smaller examples of the delistings that happen on a very routine basis that primarily OFAC engages in with the guidance of the State Department. And those are happening quite frequently, honestly. Yeah.
We're down to one last minute. Do you want to do last comments? Anything that you haven't been asked that you wanted to mention, or anything that you wanted to sum up? Rachel?
I would just say this is a very rich conversation, and I think that there's so much complexity now around kind of sanctions design. There's a need for enhanced coordination, and I think that partner governments are really building up their capacities. So, I'm very optimistic for the future in terms of improving the efficacy of this tool, making sure that it's impactful but measured in its application. Information, data, analysis, I think, can better inform the use of the tool in the future. But as kind of the conversation bears, it's a tool that I think that we have to be thoughtful about using, and to be able to have a lot of open conversation with private sector think tanks to continue to shape and make sure that it's utilized kind of as best as we are capable.
Michael?
Thanks. Again, just thanks so much for the discussion. And as I think I'll start with what Rachel ended with by saying how important it is that discussions like this happen, both with the private sector and with think tanks and events like this to kind of get more information out there about the intention of our programs, how they're structured, how our regimes work. I think, I'll just kind of I'll end with where I started by talking about the relationship and the kind of coordination that the U.S. has with its partners on sanctions, and specifically with our work on Russia, which I think has been tantamount over the last year and a half. It has been kind of unprecedented, the amount of discussions that we've had with our allies and partners. We're very thankful to the coordination that we've had with our Canadian colleagues. We're very thankful that we've been able to align many of our measures and looking forward to kind of doing much of that in the future. And as I think Rachel said, I think something that continues to be important and a goal of ours, I think, within the State Department, but specifically within my office, is continued coordination with the private sector so that they can also understand how our measures are similar and different from those of, say, Canada or other G7 partners and others who have implemented these kinds of restrictions. So I appreciate the opportunity to kind of have this discussion and hope to have more of them in the future.
All right, Rachel Fredman-Lingus, thank you so much. Michael Cass-Anthony, really appreciate it. So, over to you.
You're really good. Good. Oh, excellent.
Guys were great. Thank you.
Thanks so much.
Great work, guys. Yeah, thank you very much.
Of course.
It was really good.
Absolutely.
And you were totally perfect.
Good. I'm happy to talk to lawyers again.
Lawyers can be nice.
Yeah.
Well, good morning, everyone. Almost good afternoon. Back here as your moderator, my name for those of you who were out for the beginning is Christopher Sands, and I'm director of the Canada Institute here at Woodrow Wilson. Particularly pleased to have the chance now to focus on Canadian economic sanctions and the Canadian economic sanctions system. We have a tremendous panel here to take these issues on. On the far side, I'm just going to go in the order that I'm going to ask them to speak. That's a hint for you guys, just so you know. We have Stephen. You're going, oh, all right. I'm not actually in charge here. But I'll start by saying Stephen Burridge is Director of Sanctions Policy and Operations Division in Global Affairs Canada. And for those of you who are not Canadian, it's a relatively new outfit that they've put together. It's a small but very hardy team. And we'll hear from him first. After Stephen, we'll go to, I'm now corrected, Michael Milne, who is a partner and certified customs specialist with Cassidy Levy Kent, a firm that has offices in Canada as well as in the United States, including here in Washington. And then finally, Jessica Horwitz, partner, international trade and investment at Bennett Jones LLP, one of Canada's leading law firms. And so with that, let me turn it over to you, Stephen.
Great. Thank you very much. Good morning, everybody. It's a real pleasure to be here. And just let me say thank you to the Wilson Center and to the Canada Institute for inviting me and for putting this event together. I'm really excited to be able to speak to you about Canadian sanctions, about the cooperation that we have with our U.S. partners, and to be on a panel with such distinguished other speakers here as well, including those that we heard from earlier today. Look, I think that what you've heard from everyone here so far is that there really is an increased use of sanctions. And given the increased use of sanctions as a foreign policy tool to respond to recent and ongoing global events, there's an increasing focus internationally on strengthened compliance and strengthened enforcement of these measures. And so this really is a timely event and an opportune moment to reflect on Canada's sanctions regime, and we've heard about the U.S. sanctions regime, and so I'm really grateful to be here and have this opportunity. Look, I've had the pleasure to engage with a number of you who are here today, certainly those panelists here as well who are speaking with me today, and we've done these through previous outreach efforts. We've had interactions at similar events like this. We've had bilateral discussions. And certainly my team and I are really keen to continue to build on this type of engagement and to further bolster these vital relationships. And I think we've heard that from others today too, about how that kind of cooperation and collaboration is absolutely critical when it comes to sanctions effectiveness and compliance and to enforcement. It really is a hugely beneficial two-way dialogue when we have these opportunities. And hearing directly from you about your experiences and your preoccupations with regard to Canada's sanctions and how they intersect with other sanctions regimes helps my team and I to make sure that we're best positioning Canada to effectively and efficiently develop, impose, implement, and enforce those sanctions. So I think it's important just to start at the basics and explain the two pieces of legislation. You probably know this, but I'll go through them. I won't go in detail, but we do in Canada have two pieces of autonomous sanctions legislation. First, there's the Special Economic Measures Act. That's our oldest piece of autonomous sanctions legislation. It dates back to the early 90s, I think 1992, if I'm correct. And then the Justice for Victims of Corrupt Foreign Officials Act, or the JVCFOA, or what's commonly known as the Magnitsky Act. This is the more recent piece of autonomous sanctions legislation that was enacted in late 2017. The Special Economic Measures Act itself allows Canada to impose sanctions against a foreign state or individuals and entities that are related to that foreign state, while the Justice for Victims of Corrupt Foreign Officials Act allows Canada to directly target foreign nationals independent of state-related sanctions. So there's a series of other nuances and other differences between the two tools, but I'm not going to go into those details right now, but always happy to talk further about them. We use both of these pieces of legislation to respond to grave breaches of international peace and security, to gross violations of human rights, to acts of significant corruption. Of course, we also implement multilateral sanctions, so those sanctions that are imposed by the United Nations Security Council, and we do that through our United Nations Act. In Canada, both our autonomous sanctions and our multilateral sanctions are enacted as orders in council. So that means they're subject to the approval of the Governor and Council, and that means that all of these sanctions measures enter into force upon the signature of the Governor-General, on the advice and with the consent of the King's Privy Council for Canada, or our Cabinet. So on this point, you've heard a little bit about this already today, but I think it's important just to take a moment to briefly contrast this with the process for imposing sanctions in the US. So as you'll know, and as we've heard from other speakers today, the US can impose sanctions under executive and congressional authorities. So that often means that the US is in a position to enact sanctions through a more direct process, particularly via executive orders. And we've heard people mention alignment of measures and how important that is, and I completely agree that when we act in concert with our like-minded partners with similar sanctions tools as ours, they can be more effective, they can have greater intended impact. But because of these differences in process, sometimes things may not align immediately. Sometimes one system may take longer than another, but we do strive to have as close of collaboration and cooperation as we can. There will always be differences, I think, in systems, in listings, whether that be for foreign policy reasons, for national interest reasons. But as US colleagues rightfully highlighted in their remarks, the cooperation between like-minded partners, between G7 partners with autonomous sanctions tools, between Canada and the US has been absolutely critical, especially over the last 20 to 24 months. Look, despite these differences in process, we all do face similar sanctions demands and challenges. And as we've all witnessed, the global landscape has changed dramatically. and with it, those demands and challenges associated with implementing, enforcing, and regulating Canadian sanctions has expanded exponentially. In this way, I would be remiss not to talk specifically about the increasingly significant role that the use of sanctions has played since February of last year following Russia's invasion of Ukraine. And again, Michael had spoken a bit about the vital cooperation that's taken place since that time, and I would echo those comments wholeheartedly and really thank our U.S. colleagues for all of the excellent collaboration we've had before that time, but certainly since that time as well. Both from an info sharing perspective, both from a mutual learning perspective, and also from being able to work cooperatively on enforcement and evasion efforts. So since February of 2022, Canada's imposed over 60 new rounds of sanctions against Russia. That includes designating over 2,700 individuals and entities in Belarus, in Russia, in Ukraine, and Moldova under the Special Economic Measures Act. We've also adopted new measures including import and export prohibitions, shipping ban, prohibition on certain services to key Russian industries. In addition to responding to Russia's aggression over the last year, Canada has also imposed sanctions in response to situations in Haiti, in Iran, in Myanmar, as well as in Sri Lanka. With the broadening use of varying scope of sanctions to respond to different international security and human rights issues, we, like others, are fully seized with the importance of improving sanctions enforcement. As a starting point, I should be clear, and this was mentioned earlier as well, that Canadian sanctions prohibit Canadians anywhere in the world, as well as any person in Canada, from engaging in certain specified activities. So that's to say, we're not putting measures on the people we're sanctioning. The prohibitions are on Canadians themselves. Importantly, contravening Canadian sanctions is a criminal offense, the consequences of which can include fines, can include imprisonment, or it can include both. In the case of our autonomous sanctions regimes, that can be a fine of up to $25,000 and a prison term of up to 5 years. For our multilateral sanctions, it can be a fine of up to $100,000 and a term of up to 10 years in prison. Look, I've heard already today too from a number of speakers that sanctions aren't simple and they're complex. And we know that and we get that. And as our sanctions measures grow in scope and complexity, so too must our efforts to enforce those sanctions. Enforcement of sanctions truly is, in Canada, a whole-of-government effort with key players across the federal government family. Our efforts to enhance enforcement also include outreach to key stakeholders, both across the country, but also internationally. And that's really with a view to enhancing understanding of sanctions, how they may apply to various activities, and the obligations of Canadians or individuals and entities in Canada vis-a-vis these measures. The engagement that we've undertaken with stakeholders has included Canadian financial institutions, the Canadian Bar Association, and various other sectors and industries. Of course, with the broadening of sanctions measures, and we really have, since February of last year, expanded what those look like and how we use these tools and stretched it in new ways. But because of that, we continue to identify new stakeholders and are really focused on engaging with those partners, including the marine transportation sector, Canadian exporters, Canadian service providers. Our outreach is also seeking to enhance national understanding of the oil price cap. We recognize very well that two-way communication is key and that outreach and engagement activities with stakeholders are critical tools to foster knowledge and to bolster compliance with sanctions. It's important to highlight, of course, that the Government of Canada cannot provide legal advice. And so as we do try to provide as much information on our sanctions measures as we can, we have that sort of area to navigate between providing as much information as possible versus providing legal advice. which I think we all know the challenges that we can face there. I'd also like to touch briefly on another important initiative that we're undertaking to enhance the implementation of effective and efficient sanctions. And this really is reflective of some of the comments around unintended consequences, humanitarian impacts, and this is something that's really top of mind for Canada in the design and implementation of our sanctions. We do have specific carve-outs or non-application clauses, exceptions for certain humanitarian activities in some of our sanctions regimes. We also have the permit process, which allows for any other unintended consequences on the humanitarian front that may not be captured by those exceptions, whereby an organization that may be delivering humanitarian assistance can make an application to the Minister of Foreign Affairs to allow for those activities to take place that would otherwise be prohibited. But the other important initiative I want to talk about is that we manage a $100,000 pot of funding since 2020. It's a modest amount, but it's something, and it does support projects and programming that improve our knowledge of potential impacts and effects of sanctions. So this year, Canada is supporting the 4th Freedom Forum to complete a model checklist of factors to consider when mitigating against the unintended humanitarian impacts of sanctions. In past years, Canada has supported the development of the UN Sanctions app, an interactive analytical tool that disseminates knowledge about the use of effectiveness of the United Nations sanctions. That's available to anyone to use. It's used by a number of the permanent missions to the UN in New York, and we've had really great feedback on the app and how useful it's been for those who are working on the ground on those issues. Canada has also supported the organization of a roundtable discussion hosted by the International Peace Institute, examining the difficulties faced by humanitarian actors when trying to effectively deliver assistance in areas where the UN, Al-Qaeda, and Daesh sanctions regime applies, as well as the development of an issue brief identifying concrete solutions for the UNSC to address these problems. Finally, we also supported the development of a research report and policy brief by Georgetown University's Institute for Women, Peace and Security, conveying key research insights on sanctions as a tool to address conflict-related sexual violence. Particularly, this was focused on the ongoing crisis in Myanmar. So now that I've spoken a little bit about efforts aimed at boosting sanctions compliance, I want to take a few minutes to discuss sanctions enforcement. So though Global Affairs Canada is the regulator for sanctions prohibitions, enforcement would not be possible without the Canadian Border Services Agency and the Royal Canadian Mounted Police. In addition to working closely with these enforcement agencies, we must also often engage with other government departments and agencies when sanctions intersect with certain sectors of the Canadian economy. So we will work with Finance Canada, for instance. We may work with Transport Canada. We'll work with Natural Resources Canada. Enforcement truly is a whole of government, frankly, a whole of Canada effort. And beyond the Government of Canada, sanctions enforcement is genuinely only possible through the engagement of the Canadian public, and this is why I say it's a whole of Canada effort. This includes through those disclosures that are made by members of the public, and particularly financial institutions, to the RCMP. In this way, we truly do recognize that Canadian financial institutions are at the front line of sanctions enforcement. Given the nature of sanctions, successful implementation and enforcement also benefits from strong international cooperation, partnerships, and engagement, which we've heard about today and talked about earlier. To this end, Canada regularly coordinates closely with allies and partners, including the US, our Five Eyes partners, our G7 partners, while designing and imposing sanctions to achieve common foreign policy objectives, whether it be addressing breaches of international peace and security, violations of human rights, for example, but also to tackle circumvention and sanctions evasion. So, for example, Canada participates in the Russia Elites, Proxies, and Oligarchs, or REPO task force alongside Australia, France, Germany, Italy, Japan, the UK, US, and the European Union. The Repo Task Force works together to counter those individuals and entities that continue to enable and profit from the war economy with a view to fostering a resolution to the conflict. This year, the Repo Task Force identified a report on typologies of Russian sanctions evasion and issued recommendations to combat these evasion tactics. In addition to participating in the Repo Task Force, Canada is also actively sharing information with allies and partners, including with the Five Eyes, through the G7 Enforcement Coordination Mechanism, and through enhanced collaboration between the Canadian Border Services Agency and other customs agencies. These broad engagements with global partners and stakeholders are at the core of our sanctions, from their design to their implementation. Enforcing sanctions and addressing circumvention is a challenging task that will constantly evolve and is constantly evolving. The states, individuals, entities targeted by our sanctions will, as we've seen, relentlessly shift their tactics. They'll find new partners, they'll find new jurisdictions, they'll find new opportunities to actively evade our sanctions measures. We have to be nimble, we have to be proactive, and we have to be reactive in order to thwart those evasion efforts. In recognition of this challenge, the Prime Minister last year announced funding of 76 million Canadian dollars to strengthen Canada's sanctions capacity. This includes by creating a dedicated sanctions bureau within Global Affairs Canada to build on the existing team that's been there since 2018. And there's also funding from that's going to be allocated to additional resources to law enforcement agencies to enhance the government's enforcement capacity. In 2022 and in 2023, the Government of Canada made several legislative amendments to both the Special Economic Measures Act and to the Justice for Victims of Corrupt Foreign Officials Act. In 2022, we amended our autonomous sanctions legislation to allow for the forfeiture of property subject to a seizure or restraint order that were made under either of those acts, and I'll go into that a little bit more in a moment. In 2023, we amended our legislation to improve the effectiveness of Canada's sanctions architecture, including to counteract sanctions evasion by increasing information sharing authorities among federal departments and agencies. Look, I won't speak on behalf of law enforcement agencies, but I can expand on a few areas that I consider to be priorities for for Global Affairs Canada. One is implementing our new asset seizure and forfeiture regime, and of course, enhancing outreach to stakeholders. Canada was the first amongst the G7 to implement a regime to seize, forfeit, dispose, and redistribute sanctioned assets. Proceeds of forfeiture can be used for the reconstruction of affected states, for the restoration of international peace and security, or to compensate victims. These new authorities are really an important tool in ensuring accountability, and it will be important for Canada to get it right. To this end, we're working very closely with our colleagues in other departments. To date, Canada's used its new authorities twice. So first in December of 2022 for the restraint of $26 million US in funds belonging to Granite Capital Holdings Limited, which is a company believed to be owned or controlled by Roman Abramovich. And then more recently in June of 2023 for the seizure of a Russian registered cargo aircraft, an Antonov 124, that's believed to be owned or controlled by Volga Dnepr Airlines. Core to our approach in this regime is procedural fairness. And the regime itself includes a number of procedural safeguards, including for those whose property is the subject of a seizure or restraint order, or those who have third-party rights or interests in the asset who can request an administrative review of the order. Finally, as Canada continues to announce new sanctions and as these measures expand in both scope and complexity, we will continue to expand our engagement with stakeholders both within and outside government, particularly with those at the front line of sanctions compliance. We will continue to engage partners, including in the banking and legal sectors, and our list for planned targeted engagements is growing. Our goal is to develop national understanding of Canada's sanctions regimes and, in turn, to enhance compliance further. Internationally, we will continue to work with our allies and partners to mine data, to share information, and increase diplomatic efforts to inhibit sanctions evasion by state actors and designated entities. I think I'll leave it there. I'm probably gone well over my time, but I do appreciate your time and appreciate your interest, and I'm really looking forward to hearing from the other panelists and from you, so that I can take your thoughts and reflections back to my team in Ottawa and think through those thoughts and action them accordingly. Thank you.
Thank you very much, Stephen. That was really useful, and in particular, conveying Canada's sincerity to get it right in so many different ways, which is really important. Let me turn now to the people who can give legal advice on these things, starting with Michael.
Sure, thank you very much, and just echo my thanks for being here. It's an honor as well. So I am a lawyer advising private businesses in Canada and North America, so I bring that perspective to things, and a lot of what I will say has already been echoed, or I will echo what Stephen said earlier, but you can't speak about Canadian sanctions vis-a-vis U.S. sanctions without talking about the, for lack of a better term, like lack of guidance from the Canadian government on these sanctions issues, which we heard about from Stephen earlier today. And I won't dwell on it because the point has already been made, but just want to emphasize that and then sort of take you to the logical conclusion about where that leaves us in Canada. So you heard, well, you're familiar in the U.S. of the OFAC guidance in the thousands of issuances of guidance. There are less than 20 FAQ answers in Canada, none of them addressing how to interpret sanctions laws. And to be fair to my friend here, they can't provide legal advice. That's where we come in. It makes for good business for us. But to take it further than just the FAQs, there's also very limited opportunity in Canada, although thankfully it's expanding, to directly engage with the government on issues as they come up. I understand from my U.S. colleagues in D.C. that if there's an answer that you need that's not provided by an FAQ, you can reach out to an OFAC officer and get some preliminary guidance from them. That's not really possible in Canada. There is some opportunity to engage, but the answers are limited. And then on the legal side of things, there's really only a handful of judicial decisions that provide any sort of insight in Canada. And that's certainly not the government's fault, but we are limited as lawyers as to what we can draw on to actually give the legal advice that our clients so desperately need. And it really comes down to a place where when you're actually providing legal advice to clients in Canada, is all you can do is give them a risk assessment. Very rarely are you able to say with certainty one way or the other. In those cases, great, they do happen, but they're rare. You're almost always in this nebulous middle zone where you're describing the risk from something between negligible risk to high risk and using words in between that would fall in between those, which leaves clients unsatisfied in most cases because what are you supposed to do with an assessment that leaves you with a, quote, non-negligible risk, which is, a low risk but not something that could be ignored. Those types of opinions get issued, and it leaves clients in a super tough position. The unfortunate reality is that we as law firms, the clients are looking to us to take on the risk of the assessment, to say one way or the other, but we just can't do that because we will then face the wrath of the Canadian government if somebody steps offside. And I just wanted to give just one example, which my friend might be aware of because it's subject to a permit application at the moment, but there's a huge stack of permit applications on their desk. So there's a company in Canada who was seeking this opinion, and they got a sort of a non-negligible risk assessment, but it led to a situation where they couldn't get audit services provided. So they're not able to go through like a end-of-year audit. The accounting companies wouldn't take on the risk themselves, which just leaves them totally like hamstrung. What are they supposed to do? They can't issue financial statements to to their investors, and there's nothing to be done, and they're sort of waiting in the queue for, I think it's now 9 months, and wait and continuing. So we heard about this again from Stephen, but the only option that you're left with is to file these permit applications where you set out all the facts of what you're dealing with, and you basically go to the government and say, hey, what do you think? And can I do this? And you get one of 3 responses back. They either come back and say, go ahead, we don't think that this covers a prohibited activity. And you get that in writing, which is super helpful when you get that. Or they say that it is covered, but here's your permit, and here's that requires the minister's signing authority to do that. And once you have the permit, you're allowed to conduct that activity. Or yes, it's covered, and you don't get your permit, and in which case you should stop immediately. Those are super helpful answers, and you can take those to the bank, but anything short of that, you are left wondering. And the unfortunate reality is that there are, I don't know the exact number of permit applications at before the GAC team, but it's in the hundreds for sure. And wait times can exceed a year. I've heard in some cases 2 years, which for commercial businesses looking to undertake a deal with some party is just not realistic. You can't wait an indeterminate amount of time looking for that result. And so what this ultimately drives to is, well, you heard it earlier again from Stephen, de-risking, but over-compliance amongst Canadian businesses. The Canadian private sector is disadvantaged globally by this reality because they simply can't react as quickly as their American counterparts can, that would have the OFAC FAQ guidance. Oh yes, like there's a general license, I can do that, but in Canada you don't have that. It leaves Canadians, a lot of individual Canadians, in circumstances where they're almost certainly in violation of a Canadian sanctions law, but there's nothing they can do about it. Like Canadian citizens who may have, for instance, a telephone plan with MTS, which is a major Russian telecommunications company, not in Russia necessarily, but elsewhere in Europe under that company's telephone plan, arguably could be in violation of Canadian sanctions, but there's nothing they can do. Whereas I understand in the US, OFAC has issued a license specifically for that situation. So yeah, super unfortunate for private corporations in Canada, but they just are at a disadvantage through this over-compliance reality. Then I wanted to turn to the enforcement environment in Canada. And again, we heard a little bit about this from Stephen earlier, but there's been very few instances of enforcement, at least public instances of enforcement in Canada. He mentioned Lee Specialties. There are a couple other instances of charges having been laid under sanctions laws in Canada that I'm aware of. Yadagari being one, that was under the UN Act. And Calais, I'm not sure if I'm pronouncing that right, but a Syrian businessman who was charged, ultimately acquitted of the charges. And then there have been a handful of other export control related enforcement actions in Canada, which are related but separate from sanctions, obviously. This enforcement reality is driven by the fact that we've heard it now a couple times, but sanctions in Canada impose criminal liabilities. There's no scope in Canada for the government to impose administrative civil liabilities. Just last night, I was on the OFAC website looking at the fines that have been issued through this year. I think it's in the 500 million USD so far this year. There's been 0 penalties of that type issued in Canada. And so what this means for Canadian businesses in real time is that people don't spend I know there are institutions that have to. The banks, for sure, are very aware of all Canadian sanctions and such, but for individual Canadian businesses who are faced with these sanctions risks, they have a real business decision to make. They can either choose to over-comply and forego the opportunity, or they can choose to take the risk, even though they're getting advice from us that, yes, there is some level of risk involved with this activity. We can't tell you it's a certainty one way or the other. And in many cases, they undertake those actions because the business opportunity is worthwhile to them, and they have seen a relative lack of enforcement in Canada, publicly speaking, so that they're taking on this risk knowingly in that context. Which I think is not what anybody wants. I don't think it's what the government of Canada intends. I don't work for the government of Canada. I can't speak for them, but my sense is that it would be best if everyone knew the rules and complied with the rules as they are intended. They're not intending a complete embargo with Russia, although in many cases that's what they're getting, just through this risk of this chilling effect. If they were intending a complete embargo, there's a tool for that. We have a tool called the Area Control List. If you put a country listed on that list, it's essentially a total block on dealings with that country. North Korea is on that list currently, and Russia presumably could be added, but that's not the intent. We want to continue to allow Canadian businesses to do business with Russia, but in reality, that's not happening, or it's happening less than it should. So that's a problem. Having said all of that, there are, the RCMP has published, and I don't think anyone's mentioned this, so I do want to just put this out there, that there have been, I think $140 million of assets frozen as a result of the Russian sanctions so far, and $305 million of transactions that have been blocked. I assume the RCMP is counting those based on reports from the banks, and so they're relatively robust. But that's different, of course, from the penalty side of things. Like you're not able to conduct your transaction is one thing, and the sanctions seem to be somewhat effective in that respect, because the banks are taking it seriously. But the penalty side is not for people who can exist outside of that financial system, who have access to other banks around the world. They're not facing much risk of enforcement in practical reality. So I think that was all I wanted to comment on, actually. So I'll turn it over to you.
Over to you, Jessica Horowitz.
Thanks, Chris.
Yes.
Thank you so much for the invitation, and it's great to have opportunities to have dialogue like this with our government colleagues and share ideas in open forums. So I think this initiative is a really good one. I'll also just give a disclaimer that my views are my own. They don't represent the views of any of my clients or my firm. And I'll also say that none of my comments represent legal advice. You're not the only one that can give that caveat, Steve. Of course, if you want to hire me, we'll give you legal advice. I'll start with a few comments just to respond to some of the other things that I've heard from colleagues today. And so just picking up on this theme about the risk analysis in making decisions about whether or not to proceed with a particular activity. And I think that Stephen this morning mentioned in his presentation that the costs of compliance have been skyrocketing in recent years. And a big part of that is, I think Rachel in the previous panel mentioned the trend away from full embargo style sanctions to targeted list-based sanctions, which is good from a public policy perspective because theoretically you're minimizing the unintended consequences. You're trying to make the sanctions as targeted as possible to the particular actor whose behavior you want to affect. But it also makes it a lot more complicated. It makes it a lot more difficult to navigate. And the Russia sanctions that Canada has is a perfect example of that, because you've got nine schedules. How many schedules are we up to now in the regulations that have various different purposes? There's export restrictions under about 5 or 6 different categories of the type of export restriction under the Russia regulations, depending on what the product is and what provision of the regulations it's restricted under. And so for average businesses that don't have a lot of sophistication, such as, for example, the banks do in the area of sanctions compliance, it's a real challenge. And I would say that, in general, Canadian businesses want to be compliant. It's not like Canadian businesses or my clients are calling me and saying, Jessica, how do I evade the sanctions? That's not the conversation. The conversation is, we want to comply with the law. We want to be responsible corporate citizens and do what's right. But at the same time, we have obligations to our shareholders to maintain profitability. We have obligations to our counterparties under contracts to complete transactions that we've agreed to. And so when you're trying to determine whether, for example, a transaction needs to be terminated on the basis of sanctions, the question of whether or not it actually is prohibited by law is a extremely relevant question. Because if you are over-complying in a context of a corporate transaction or some kind of commercial arrangement where you have potentially termination penalties, then sometimes you can terminate on the basis of a force majeure. There's been a change in law. It's impossibility. We can't complete the transaction because it's prohibited by Canadian law. But if it's a gray area and it's not clear based on available interpretive information whether or not the transaction is prohibited, then you as the company that's making this decision can find yourself in the context of a contractual dispute. And you could be sued by your counterparty for wrongful termination of the contract or failure to perform the contract. And so it's not that, so over-compliance is also not necessarily an option in all cases. I've had a client comment to me before that, in the heat of, very complex transaction, we're trying to navigate all these questions and interpretive issues. And he said to me, I kind of wish the Canadian government would just impose an embargo, because that would just make it easy. Because I could just tell my counterparty, listen, I can't do it. It's very clear. There's a full, like the Cuba embargo, the U.S.-Cuba embargo. It's a full no-go. It's easy to point to. Whereas with this ambiguity, the company is in this situation of having to navigate and thread that needle. Which becomes very, very challenging. It becomes costly when you have to, hire expensive outside lawyers. Not that we're expensive, but yeah, it's great value. It becomes time-consuming, which is also extremely costly. The delays in contract negotiation or in the time that you need to consider the legal risks might mean that opportunities pass by and you miss opportunities that are fully permissible under the law, but because you had to do this deep dive on the compliance and you weren't able to maybe get timely guidance from Global Affairs to clarify, the opportunities are lost. And so I just wanted to echo Michael's comment about the competitive disadvantage that this puts Canadian companies at compared to, for example, similar companies in jurisdictions that have clearer guidance, like the US and the EU and the UK. So that was just sort of introductory comments. When Michael and I were talking yesterday about, okay, well, what are we going to cover? We're in the privileged position of being private sector, so we can say what we really think. And so I agreed that I would talk a little bit about some of the statutory amendments that we've seen recently in Canada and the changes to Canadian law. And I think on the whole, they represent incremental improvements to Canada's sanctions laws. It strengthens the legal mechanisms available to the government. And also some of the amendments have clarified some of the policy purpose, for example, behind the sanctions. It's still a work in progress, but there have been, I think, improvements, particularly in the rounds of amendments that we've seen in the last 2 years under the two budget implementation acts in 2022 and 2023. So just to run through some of these, and I'll maybe give comments as I go. So we have in the 2022 amendments, there was an expanded definition of property added to the Special Economic Measures Act, which expands property to clarify that it includes intangible assets such as cryptocurrencies. So this is an emerging ground for sanctions evasion is using virtual currencies, and so that has clarified that property is not only physical property, tangible goods, but also, money, financial instruments, securities, virtual currencies, all those types of assets. We also, in 2023, there was an amendment that has given the Government of Canada the formal ability to restrict, under sanctions regulations, the making of property available to a listed person, whereas before it was focused on goods, so you can't make goods available, and so that's expanded to now include the ability to restrict all property, which is, I think, was the intention of the original sanctions, but that was identified as a gap, and so that's been closed. We have a purpose statement that was added to the Special Economic Measures Act in 2022 that clarifies the policy grounds under which Canada can impose sanctions, which include 4 grounds. So it's basically if an international organization has given a directive to do so. So the implication being the United Nations General Assembly, perhaps going to the discussion in our previous panel. If there's been a grave breach of international peace and security, which that's always been in there. And then we have the 2 relatively newer grounds that were added, I think, in 2018, along with the Magnitsky 2017, thank you, to implement sanctions in the event of gross and systemic human rights abuses or significant acts of corruption on the part of public officials in a particular location. And so that's helpful to clarify the scope of the policy imperative that underpins the sanctions, although I'll have another couple of comments about how that's implemented in practice in a second. So there's been improvements in information sharing with other government departments. So the recent amendments in 2023 added, actually in 2022 and 2023, there were additional government departments added that Global Affairs is allowed to share information with, and that can share information with Global Affairs to take the whole of Canada approach, whole of government approach to policy development and enforcement, including notably FINTRAC, which is the regulator that's responsible for anti-money laundering and receiving reports of suspicious transactions from financial institutions and other categories of reporting entities that have specific regulatory anti-money laundering obligations. And FINTRAC, unlike Global Affairs, has a long history of experience being a regulator. And so my view is that information sharing and support will be ultimately beneficial. And the other thing that we saw in the most recent amendments is that reporting entities to FINTRAC now have to also report frozen assets to FINTRAC. So again, it's instead of going to the RCMP, you go through FINTRAC, and it's just clearer how that reporting mechanism is supposed to work. This is before I get to the 2 big ones, which is the deemed ownership rule and the forfeiture. But just another comment about the most recent round of amendments to the 2023 Budget Implementation Act is that there was a change to the wording in the CEMA that gives Canada the power to impose list-based sanctions on a person outside Canada who is not Canadian. And that's a change from the previous wording, which focused on the target country, the jurisdiction under which the regulations were being implemented. But now, theoretically, this gives Canada the ability to impose effectively secondary sanctions because it allows, as long as the grounds for listing in the particular sanctions regulation are met, I'll get to that in a second, the person being targeted doesn't necessarily have to be in that jurisdiction anymore, or a citizen of that jurisdiction. It can be a third country person that is perhaps supporting the gross violations of human rights. So that it's not clear, and maybe Stephen will have some comments in the Q&A section about this, but it's not clear exactly how the government plans to use this this power, but it is an expansion, which is an interesting development. Okay, so the two big changes that we've seen in the last couple of years has been the deemed ownership rule, which Stephen spoke about in his presentation. And that came into effect in June of this year, and it has caused a lot of consternation. In some sense, it is helpful because at least we have a rule now. I would say actually there was probably more consternation before. But again, along this comment of I wish there was a full embargo. Sometimes it's better to have clarity, even if the clarity is not exactly what you would have picked, better than ambiguity. But so the deemed ownership rule, we have a 50% rule, but in addition to that, we have an effective control rule. And what we don't have is guidance from Global Affairs, sorry, Stephen, about how the government intends to interpret the scope of effective control. And this is a really relevant question for businesses because the question is, what due diligence is sufficient due diligence? What documents do I need to request from my counterparty to ascertain whether a minority shareholder that is subject to sanctions has the ability to change the composition of the board of directors? Right? And the information that you need to be able to determine that is sometimes confidential. It's in the shareholders agreement or it's in the bylaws of the corporation. And if it's not a publicly traded corporation, that wouldn't be public information. And so then it becomes a negotiation with your counterparty of are they willing to disclose this information to help you get across your due diligence threshold and obtain a reasonable level of comfort with the transaction to demonstrate due diligence in the event that there was some kind of enforcement action later. So some guidance would be very helpful, I think, to businesses to clarify that. And this is not the first time that the legal community has made this comment to Global Affairs. We've engaged routinely through the Canadian Bar Association and other organizations. So, and I understand they're working on it. So the other big change that we've seen in the last couple of years that Stephen touched on in his presentation is this forfeiture regime. And this is a really interesting one because it is a bit of a test case for the rest of the world, or at least the G7 states, in whether this idea of the ability or the moral justification or the international law justification of confiscating assets from sanctioned persons is going to be feasible in practice. And by feasible, I mean that it can happen without being blocked by applicable domestic or international laws. So constitutional challenges or challenges under state immunity principles under international law and things of that nature. So Canada is a bit of a trailblazer, and I think that our other colleagues in the G7 are watching the two example cases that Stephen mentioned with great interest, and which is why he mentioned that Canada is being very careful about making sure that they do it right and compliantly with applicable laws. But I'll just maybe add a few comments, and again, my own thoughts about the forfeiture regime. The key question and why it's controversial is the question of whether the expropriation of private property is acceptable under established legal norms. And so whether that's domestic property protections or international law principles in investor protections. So under the Canadian Charter of Rights and Freedoms, we don't have a formal protection of property right, the way that exists in some other jurisdictions, like the US, I think. The Bill of Rights, the Canadian Bill of Rights, does have a property protection, but that right is not does not constrain the government from being able to expropriate property through legislation. And there's been Supreme Court cases that have confirmed that. So as long as the legislative intent is clear that is the intention, the government is able to do that, and it's not constrained under constitutional principles. And so the main question becomes the international law considerations. The question also is seizure of the assets, because of course there's two steps to the forfeiture regime. One is that the assets are seized, which is actually, I guess it's 3 steps, because the first is that the assets are frozen or restrained under the applicable sanctions restrictions. The second step is that the government actually issues an order or takes action to seize the assets, which puts them in a formal category of seized assets that are subject to management by the federal government, as opposed to being in property in private hands. And then the third step is once the Canadian government gets approval from a court, they can actually treat those assets as forfeit, which means that they can be sold, they can be disposed of, and the proceeds can be used to put towards the designated grounds in the legislation, or the designated purposes in the legislation, which is effectively reconstruction efforts, compensation of victims, or the restoration of international peace and security. So it's not, the government can't just put the money into its general coffers and use it like tax revenue. It has to be used for very specific purposes. So the question is this seizure an unreasonable seizure? Possibly not, as long as due process is followed, because the government does have a right of seizure that is not subject to a criminal standard of proof. So one of the criticisms is that what you're doing is you're essentially seizing as forfeit assets of a private individual where there has been no criminal conviction. There's been no criminal process with evidence on a standard of beyond a reasonable doubt to demonstrate that there's been a criminal offense committed, and therefore that you're not justified in taking these assets from the person. That's not exactly right, because Canada does have an ability to seize assets, for example, under the proceeds of crime legislation. The government does have the ability to seize and sell and forfeit assets that are. I believe the standard of proof is the balance of probabilities that they were assets derived from the commission of an offense. So it's a bit analogous, I think, the sanctions context. But of course, all of that's subject to due process. And so that becomes the difficulty, I think, in this new forfeiture legislation, because the court approval, or the approval from the Superior Court in the applicable province where the property is located, is only required to confirm that the property is in fact property that is owned, held, or controlled by or on behalf of a listed person. So the question that the court has to look at is this property owned by this person? And then there's the process that Stephen mentioned for third parties that have an interest, a property interest, or a debt or a lien or something in the property can try and assert that. But what it doesn't do is ask whether the listing in the first place was justified. And there are separate procedures under Canadian law whereby those types of decisions can be challenged. So the decision to list a person on a sanctions list is subject to judicial review in Canada. There are currently a number of cases before the federal court in which individuals have challenged in various different respects the listing decisions. We don't have any published decisions yet, but I know that we'll be watching that space very closely to see what the federal court says about those cases. There's also, of course, a mechanism to apply for delisting from Global Affairs, which is, again, that decision is subject to judicial review. The difficulty with that we've seen in recent cases is that there's a lack of information, there's a lack of transparency available to the person that has been targeted by the listing measure as to the grounds for listing and the evidence that underpinned the listing. And so the government can't just list people indiscriminately. It has to be individuals or entities that meet the requirements in the applicable regulations. So I'm just looking here at the Russia regulations as an example. And you've got Section 2 that says a person that's listed on Schedule 1 is a person that the Governor and Council is satisfied there are reasonable grounds to believe. And again, it's a reasonable grounds test. It's not a proof beyond a reasonable doubt test. whether it's a person engaged in activities that directly or indirectly facilitate, support, provide funding for, or contribute to a violation or attempted violation of the sovereignty or territorial integrity of Ukraine, or that obstruct the work of international organizations in Ukraine. The second one that was added after as an amendment was a person has participated in gross and systemic human rights violations in Russia. And then the rest of them are former official of the government, associates of persons listed in A and B, entities owned and controlled by persons listed in A and B. So it all flows back to this, there has to be some person involved that is engaged in activities that directly or indirectly support the war in Ukraine or that involve human rights abuses. And that's the evidentiary thread that is opaque to a lot of individuals and entities that have been the target of sanctions. I'm not going to name any names, but we've been approached by various different individuals and entities at various points saying, how do I challenge this? I have no influence with Putin. I have no involvement in the war in Ukraine. All I am is a rich Russian person. So, I'm not engaging in human rights abuses. This is what they say. And so starting from the assumption that, okay, maybe this person is telling the truth and they are in fact not involved in any way, how do they prove their lack of involvement to global affairs in a way that's going to encourage a delisting decision? How do you prove a negative? And it's even more difficult when you can't get disclosure of the evidentiary basis for the listing in the first place because it's protected by cabinet confidence. It's withheld from disclosure, which I think one of the U.S. Speakers was mentioning this morning is also the case in the U.S. So because it's in national security issues, it's highly sensitive. And so it becomes a question of how do you ensure that due process and procedural fairness is followed to make sure that you're not arbitrarily or illegally imposing sanctions on an individual entity or forfeiting their assets and seizing and confiscating their assets without sufficient evidence. What is the evidence? What's the standard of evidence to be met? And I have a question. I don't have an answer for that question, but it is an important question that I think needs to be asked. So maybe I'll pause it there because I think I went over my time.
Well, I think we've almost run out of time, but I feel like lawyers are interested in justice, and the structure of this panel really had the both of you, Michael and Jessica, talking about what Stephen does every day and his presentation. So I want to turn it to you, Stephen, a little bit, and I'm going to ask you very specific. If there's anything you need to respond to here, please do. But also, if you could, in your mind, and maybe we'll close with everyone jumping in on this, what can the U.S. do to help Canada do what it's trying to do? How can the U.S. either be leaned on or supportive in terms of sharing information or what have you? Because if there's a way that Canada and the U.S. can work together, that's something the Wilson Center and I think the Canada-U.S. Law Institute would be very much in support of. Yes, perhaps they can give legal advice. All right, over to you, Stephen.
Thank you very much, and thanks to both to Michael and to Jessica as well. I think what I take away the most from this conversation is how important these kinds of conversations are, right? And I think, as you said already, Jessica, we do have these conversations regularly, and we plan to have them even more regularly. But a few things maybe just to comment on very, very quickly. I think when it comes to, I hear you on guidance. Let me be very clear. Hear you on guidance. We know that very, very well. It is a tricky one, as I mentioned before, because of that fine line between legal advice and providing the kind of granularity on guidance. I would say that we already undertake a lot of outreach like this to explain our sanctions measures. There are FAQs, I get it, they may be limited right now, but they are available on the website. There is a mechanism to contact people within my team to be able to discuss things that fall outside of what's available right now publicly. And then finally, there is a permit process. I certainly don't want to make any sort of excuses, but definitely since February of 2022, the world has changed. The sanctions world has changed. That's what we've been talking about primarily here, right? Complexity has changed. The sheer volume has changed. My very, very small team has been working tirelessly to try to engage with stakeholders and offer as much information as they can on these measures. But it is a work in progress, right? And the government has committed additional funding to expand that capacity, and part of that capacity in terms of being able to have better enforcement, better compliance, means being able to dedicate some of those resources to digging into some of these questions that you have and trying to tackle this question around further information and guidance. So hear you loud and clear, and we want to continue to have that discussion. Please, as you've done, continue to flag where these sort of sticky points are, so that we can think through the best advice that we can give. So I'd say that first. Otherwise, what I would say is that in the meantime, Canada's been very, very clear, especially when in the Russia context, right? We have taken very, very robust measures with the intent of stopping the Russian war machine and bringing about an end to the conflict. Both the Deputy Prime Minister and the Prime Minister have been very, very clear that there will be impacts on Canadians, for sure. I think that you used the example, Michael, of the telecommunications company. The intent there was to cut off people using that telecommunications company, right? And so when we talk about the permit process, permits are meant to be issued in exceptional circumstances, right? That activities are prohibited for a reason. If there are national interests, if there are foreign policy reasons why a permit should be granted, then that's something that the Minister of Foreign Affairs can certainly consider. But in interpreting the prohibitions and the regulations right now, I would say, bearing in mind the very robust approach that the Government of Canada has taken, that I would encourage you to interpret the regulations very broadly as well. Maybe very quickly on deemed ownership. It's, as I just mentioned, like, we've taken a very clear stance in response to Russia's breaches of international peace and security. The measures that we've developed have hit a number of different sectors. They're meant to be broad in their scope. We've purposefully targeted key parts of the Russian economy with the objective of financially constricting Russia, so that it's unable to afford its war. And so in the case of deemed ownership, again, like I would just underscore, it's broad. So take a very broad approach to its interpretation. Asset seizure forfeiture maybe as the final point, and I think, Jessica, it was really helpful how you outlined some of the more finer points on that. I do want to emphasize, though, as well, the procedural fairness piece, right? And because it is really an important element of this regime and those procedural safeguards that you did outline some of them as well, right? The consideration of proposed forfeiture by a judge in accordance with a court process, the provision of notice to any person with an interest or right in the property is determined by the court, the ability of a person whose property is the subject of a proposed forfeiture to make an application to the court, asserting their interest or their right in the property, and the opportunity for affected persons to seek financial relief. So really, really important elements. I think you made a very important point that we know that others are watching how we do this, and so there is no jurisprudence on this yet, but it is a court process, and so we want to make sure that we do have very robust cases that go before any court. Finally, on the evidentiary piece, we're reflecting really carefully on what kind of information we're able to make public on listings. But it is important to note that all of the evidentiary packages that accompany any listings rely on open source material, right? So it's not that the process is hidden or relying on intelligence. All of the listings are based on open source material. They have to be. We cannot use Intel to list. And then to your point that you said yourself, Jessica, that the regulations actually spell out precisely why individuals are listed. It's very clear within the regulations, under what section people can be listed. And so if we do receive a delisting application, then there are certain bits of information that we are able to point out to an applicant, including where they may have been listed. But maybe I'll leave it there.
Can I make a comment?
Yeah.
What would be very helpful, I think, from the perspective of lawyers that help sanctions targets to challenge those decisions or to apply for delistings in accordance with their procedural rights, if Global Affairs could disclose which ground under the regulations, so which subparagraph under Section 2, for example, in the Russia regulations was the legal ground for the listing, I think that would be very helpful, because that in and of itself, even without getting into the underlying evidence that was used to establish that, it tells the person why, which legal mechanism they're being listed under. And you can make guesses, right, based on the publicly available information in the RIAS regulatory impact analysis statements and other places on the Global Affairs website. But disclosure of that, just a suggestion that might be useful.
No, thank you for that. And actually you raise a really good point that I should have, which is that there is the regulatory impact analysis statement that accompanies all the listings, which outlines why individuals are being sanctioned. There's often news releases or other statements that are issued as well by whether it's the department or the minister, or in some cases the prime minister as well. So there is information out there, but like I said, we're reflecting really carefully on what that looks like in the future.
Michael, anything?
I was just thinking about your question, what can the U.S. do to help Canada? You're probably better placed to answer that than I am, but...
and I apologize, Chris, I missed that point when I was responding there. I would say that our U.S. colleagues have been nothing short of extraordinary when it comes to having conversations about anything sanctions related, including the provision of guidance and how they're doing it. We have learned a lot from them. We will continue to learn a lot from them, and looking forward to continuing that dialogue.
Well, if we can support it in any way, we're happy to do so. Ladies and gentlemen, this has been an amazing conference. I want to thank our partners in the Canada-U.S. Law Institute and the WABA Institute for Strategic Competition. I want to thank Rick Newcomb. Rick, you were the inspiration for us taking this on. You led us into a real thicket of issues, but that's what we like here at the think tank. We really like to delve into them. We couldn't have done it without you. And I dare say where Canada is today and where the U.S. is today, we would never have gotten there without your public service. So thank you very, very much. Ladies and gentlemen, we are adjourned.